ఎవరు కూర్చుంటున్నా నేను ఎవరు రిటైర్మెంట్ దగ్గరలో ఉన్నాడు ఆయన ఎందుకు
30 months ఉందంటారు.
ఏరవుతాడు మంచిగా చాలా
హలో
ఫస్ట్ ఐడెంటిఫైడ్ చేసి
ఏడున్నాయి సార్ ఇంకా కాల్
మూడే ఇచ్చింది ఒకటి సార్ వేరే పెట్టేసిన బయట ఎవరమ్మా ఇంకా రాలే సార్ రోజుకో పూట
మంచోడే ఇప్పుడు పతిచంద్ర శర్మ ఎలివేషన్ సాయంత్రం ఇంకోటి చేసి సాయంత్రం వచ్చేసి ఎలివేషన్ మనం పోతాం బాగా వెళ్ళిపోతాం వెళ్ళి కార్యం కోసి
లేవా చాలా డేంజర్
ఏదైనా ముందని
చూసుకోండి కాదు
ఓకే సార్ జరిగినప్పుడు
ఎంకరేజ్ చేసుకోవాలి
అక్కడ తక్కువ పెట్టు
అక్కడ బాగుంది అలా కోట
కొత్తగా వచ్చినప్పుడు ముత్తరాలు వినాయక వినాయక కోటి
రెడ్డి గారు చాలా పెడతా అన్నారు కదా జాన్ షేక్ జాన్ ఆశా పేరు సార్ మర్చిపోయారు వెంకటేశ్వర రావు సీనియర్ కోర్ట్ ఆఫ్ వెంకటేశ్వర్లు వాడు మీ వాడు నల్గొండడు కోట కోర్ట్ మాస్టర్ అయినా కాదు లక్ష్మణ్ సార్ నమస్తే. ఇంకోటి మీకే వస్తాయి.
మీరు ఉంటే అక్కడ మా వాళ్ళు ఉన్నారని కాదే నువ్వు మంచిగా చేస్తావు, కోఆపరేటివ్ గా ఉంటావు. మాకు మీలాంటి వాళ్ళు ఉంటే మాకు ఏమవుతుందంటే చాలా హెల్ప్ అవుతుంది, చాలా హైగా ఉంటావు. బెంచ్ కు బెంచ్ కు మీరు మధ్యలో ఉన్నారు. మీరు మాకు హెల్ప్ ఉంటే ఆయన కూడా హెల్ప్ ఉంటాడు. నాకు అయిపోతుంది పని. సార్ पैसा बस
आप सही बोले.
अभी तक फाइल्स है
काज लिस्ट పెట్టు. బర్డాక్స్ పెట్టు. స్పెసిఫిక్ కేసెస్ అది ఎప్పుడు ఒకటి ఇక్కడ సార్ దగ్గర పెట్టింది ఇలాగా ఇలా పెట్టి దుమ్మ లీవ్ కూర్చోబెట్టి రోజు ఏ కొట్టుకెళ్తున్నాను శివశంకర్ నాయుడు శివరావు నాయుడు జూనా జనవరి అప్పుడు 22 January. ఎన్నేళ్ళండి ఏంటి ఎన్నేళ్ళు అన్నట్లు తెలుసు బ్యాలెన్సా 8 పత్రిక సార్ నమస్కారం సార్ మీరు గడ్డాన్ని ఇస్తే గుర్తుపట్టడం చాలా కష్టం.
చికాగా ఉండిందండి, చికాగా ఉండింది.
మంచి పని చేసి కాపీ రాసిన సారే చెప్తాను.
అంటే మా లేదన్నాక నేనే కనిపిస్తాను కూడా కనిపిస్తాను సర్వీస్ అంటే ఏ కోసం తర్వాత వెయిట్ చేసి వచ్చిన తక్కువ ఇది ఇదే కదా డివైడ్
అవుట్ ఆఫ్ మెన్షన్ ఫస్ట్ పేజ్ నెంబర్ 1 తర్వాత ఉన్నారు థ్యాంక్ యూ విషయం లేదు క్వశ్చన్ క్లాస్
2008 లో పాస్ అయ్యింది 10 లో పాస్ అయ్యింది 10 పాస్
కలిపి ఫోన్ చేసి ఫోన్
ఓకే
మేము అయితే అంతా వాళ్ళకే చెప్తాం కోర్టులో బిజీగా ఉంటాం కదా వాళ్ళే చూసుకోవాలి ఆ ట్రైనర్లకు ఇచ్చేస్తాం వాళ్ళు ఫోన్ చేయొచ్చు జడ్జిగా చెప్పకుండా వాళ్ళు పోయి ఫోన్ చేస్తున్నాం చేయాలంటే అపాయింట్మెంట్ సార్ అపాయింట్మెంట్
మెమో ప్రకారం
మెమో లేదు చూడండి లేదు సార్ ఉంటుంది కానీ మెమో లేదు
వాళ్ళ కాంపిటీషన్ దీంట్లో అది ఏపీలోనే
Thank you for that. ఆనందం సార్ మీ ఫేస్ కలర్స్
సార్ మాకనే ఏం కనిపిస్తున్నారు మా లేబర్ మీరే కొట్టేస్తున్నారు
నరేంద్ర అగర్వాల్
ఫోటో చేసుకోవాలి పని
Mr. Court Master?
బాబు సార్ వచ్చిన తర్వాత ఆన్ చేసి అది స్ట్రీమ్
Senior party. Senior Gandhi.
unofficial elevators రవి ఫస్ట్ పని చేశారు కాదు మధ్యలో ఆయన కోర్ట్ మాస్టర్ సార్ అంటాను
I think personally, it can be run.
इतना लिखा नहीं होता बस अब बेटा हम समझ कोशिश कर रहे हैं प्रैक्टिकल how much है आधे से देख रहा हूँ एक चीज अच्छा आप लोग आ रहे हैं हमारे
Silence.
Page wise mentioned. Page 1 to 17. Page 2 18 to 30. Page 3 31 to 46. Page 4 47 to 67. Page 5 68 to 87. Page 6 88 to 97. Out of mentions. Item 1 PVSS Ramarao GP for transport D Ramakrishna.
Explaining the order process by government, altering the declaration date. Notice respondent filed a call. There is an interim order. Notice respondent filed a counter and vacate application.
Respondent number 4, we have filed vacate state. We have come on record on first number.
Clear counsel is imagined.
We have notice for the order to the client.
Required time?
First time,
You require time or you ready?
I request. Construct the file. Because it is abandoned.
You want?
course of 2 weeks.
2311. 2311. 24. 24. 28. 2811.
Item number 2.
At the request of council for respondent.
B. Kishore or Chandrasekhar Reddy.
Will the conditions in that patients over matters, I have filed the copy of the orders also in that. Just kindly see page number 19. The part-time employee, as per UMS number 12, the work in 10 years. As on date of 25/11/1963.
Who is for response?
Respondent the P. Kishore Rao and P. Kishore Rao. Respondent. I also informed. Also, papers also communicated last time. 4 weeks.
He is appearing Miss Akram. Is for school education. Ishwaro, Chandrasekhar. Also, the count is already there.
Counter file.
Count already filed.
Counter.
Also, let him see. Only I think the counter, the ground taken by that Krishna is not within the 10 years.
10 years, but that is not correct. Page number 14 for a moment. Page number 14, that is bracket. This is the certificate issued with the respondent's plan. These two certificates that D. Ramlu, son of Sir, has worked as a part-time, whereas from 1979 to 1981.
But I think you are again appointed 1986.
79.
No, again you are regularized in 1986.
Not, and also not the, not even the B. Srinivasan case covered matter, that is Supreme Court order, Lordship Justice Almester and also the Justice Abhay Manohar. This not the Lordship policy, the para 7. There are 7 and the 4th line, the respondent municipality being a statute body is obliged by the GOMS number 212. In this case, not 212. Despite of the above mentioned GO, the response keep quiet for the almost 20 years without addressing service of the applicant and continue to start the work from the applicant. In the certain refusing benefit of the above mentioned GO, on the ground that the appellants approached the tribunal belated and in our opinion is not justified. In the circumstances, the appeal is allowed modifying the order under appeal by directing the respondents, by directing the appellants services be regulated with effect from the date of their completion of their 5 years continuous service as was later known by this court in district collector chairman and others and ML Singh and others case of 2009 HIGCC. Accordingly, he completed.
Also, you think.
Item number 3, G. Umarani.
Register password tomorrow or Monday.
Saturday
Monday.
is holiday. Tuesday. Saturday also is working.
Yeah, yes, sir. You lost the sir.
18th. Next Saturday is fine. Next Saturday, 18/11.
Next, sir. Yeah, okay. Okay.
No further orders have
Which is
item 3 months.
Item number 3, G. Umarani, GB for
Saturday uniform.
human development.
Saturday. Uniform.
Uniform.
School for education that 18/11 years to come.
18. Okay.
I got it.
Already promoted. What? Become infectious.
They have it tomorrow alert.
You are appealing for?
I'm applying for the petition.
Initially.
I didn't have it tomorrow alert.
Only
It's, there are two matters of this particular petition, my lord. One is regarding the promotion. I'm confused.
so this is promotion.
No further orders are necessary, my lord. It has been already.
It's a promotion only.
Yes. No further orders, sir.
Council of Commissioner.
Habibuddin, Chief for Home, MV Ramarao.
Yes. Who is appealing?
Special GP for whom?
Who is it? Is what you have gone through the case? What is this case? Already filed OA, that was already dismissed. Again you filed. You are not been selected. You are given only some serial number that you are claiming as appointment. Your location is your recommendation was they rejected. Still you want to continue. Nothing is. Who is the shall pass or all the dictated order? Then will nothing is in this. Thank you. Nothing is there in. See, your writ itself is impact if you insist on merits and then you need to the cost has to be imposed. Despite rejection of your representation several times, again you are further. On record. I think that tomorrow you could not say, but what is it? Why is this thing? We will tell you. Council for Krishna and DP Select also.
T. Lingarao, GP for Services 1.
Now, with regard to this matter, Millet, where the issue involved, my bundle is misplaced. Now, the matter issue is involved in this case, Millet, where his services were terminated on the basis of involvement of the ACB case. Ultimately, Millet, the conviction orders have been set aside in the appellate court. And pursuant to that, he has been reinstated. There was a gap period from the date of dismissal pursuant to the conviction and also reinstatement on the basis of the acquittal. That gap period is required to be regulated, treating it as duty on the strength of the judgment of the Supreme Court and also this honorable court. In fact,
Before advancement of my senior Millet, I will make a request to you take a Wednesday Millet because bundle is also not traced out. It is read as services 1 manner.
Both are equal. Equal value.
without candle, yes.
In fact, I apologize to court and senior also.
Lastly, we rightly observed. No, sometimes sometimes.
In the old matter.
No, I will.
But also, count also not, you are not filed. Count also not filed.
Even counter is not necessarily.
Sorry, but let him also take an instruction then. When do you want?
1811.
1811 started.
Any day.
Council.
GP for Services 2.
One second. The GP for services 2. And it takes to get instructions. Instructions are either instructions, resolutions or then take to file. When is that opinion?
Posted on
1811 said. Either you get instructions or get filed.
directly issue to payment of services 2 manner.
Okay. What must
Item number 6.
1 second. 1 second. This is directed to in the name of GP for services 2 instead of 1.
Number 6. M. Ramgopal Rao, GP for Services 2.
This is also may make a request of filing counters. Matter pertaining to Geo 98 manner. Displaced person quota manner.
Ram Gopal Rao, I think is GP
Standing council.
no standing council.
TSHC.
How much time? 1811?
Problem.
Count not coming.
Counter.
Appointment,
Displaced person quota manner.
even 20 years, nothing. After 15, 20 years, you are not. They are risking. They will.
The main
Your life
criteria
is on everything.
Alas, basis main criteria in June 98 color, they have to apply within 1 year manner. Perhaps the father is not allowed, son has made a representation after 10 years or anything like that.
But there is some judgment, in fact, they quoted saying that even after the delay will not be.
Well, award is it relates to award manner. If the award is before June 98 manner, no question of 1 year limitation. If the award is after Geo manner, 1 year limitation applies.
But here the award is after Geo or before Geo? In fact, then you can argue. Ready? No repetition for repetition. At the request of.
Damodar Reddy, GP for Finance and Planning, GP for Services 1 and Services 3.
Sorry, not really fine. I can't have the gift copy.
Code bundle take code bundle now. Monday is holiday. 1511 with the request of both the councils. Get ready and continue. What is this? What is the case?
Matter pertaining to HRA, 40% of HRA. Any petitions are, if there is interim orders,
There are several batch cases also.
What are those are pending?
Interim orders were granted, not suspending the memo, where 20% HRA was being paid to those persons, employees who are living in Mancherial town. So now that is being reduced by way of memo to 14.5%.
But only category, there's a category of categories, I think recategorized. These towns for recategorized.
8 kilometers.
Within the area of 8 kilometers.
Right.
Yeah, within
15, 11. The request to both council 15, 11.
Item number 8. Amalu B, GP for social welfare.
Matter pertaining to promotion.
Please, Mr. Raman. File counter?
No,
A counter is paid on,
no, yes.
counter is there on record.
Sir.
Have you, don't have bundle, bundle is there. You have the bundle or no? Without seeing bundle, how can you say that counter is not filled up? Third response, second and third response, all responses. And you want where is this done? Request, no request for question.
Item number 9, MR Tagore, GP for revenue, GP for services 2.
Yes.
Seeking promotion as a Tahsildar emotional industry. Because he got promoted on 13/3/2013 because of pending some different proceeds belatedly. And the juniors got promotion on 1/9/2011, 2 years earlier than the petitioner. And this is the backdrop of the case.
Who is appeal?
Before advancement, I'll bring to my lord's notice for a counter is not filed. In fact, my landlord has filed a representation for the petitioner saying that to consider his case for a notional promotion. Finally, 11 and 12. I have received a letter from the authority to take adjournment. If my lord, my friend doesn't have any objection, let them take decision on the representation by fixing some time. Because in the letter they have addressed, they have to get the records and everything. It requires some time. Now the election time, election duties are there, they're requesting some long time.
After 6 years.
No. 2 months,
The case is very simple, 1 minute.
My only endeavor is that,
Can be disposed of.
if
And also only
when agrees, representation is there.
disposal of.
Representation is
Say
there.
representation.
Here, what happened? When working as a senior assistant, 1989 the charge memo was issued 2010. Pending charge memo, thereafter, my lord, the punishment also incurred. Appeal filed, that is stoppage of an increment. Appeal filed, appeal also rejected. Then I filed a OI before Honorable Administrative Law. While pending OI, my juniors were got promotion. That is 2011. Then my lord, the Honorable Tribunal allowed my OA, set aside the punishment, saying that without inquiry, proper inquiry, without examining the witness, the inquiry is bad and set aside the punishment. Because of pending OA, juniors got promotion during currents of punishment. When the Honorable Tribunal set aside the punishment, I am entitled for promotion on par with my juniors. And see my prayer melody. Later the tribunal orders, my case will be considered. For which melody can dispose the and see melody. There's 5 melody, my relief melody.
That is the version he has taken in the representation.
The same version.
That's what I said. Representation melody, what happened? We brought this
That's fine.
tribunal order.
In fact, my lord, with great respect to my senior, he has to file that contempt. failed to file the content. All the and everybody is
My
filed.
lord,
Too frankly speaking,
my lord,
too frankly, let him enclose that orders and everything, my lord. I'm as an officer of my lord's court, my lord, I cannot deny it because it is already set aside. That punishment order, he is entitled for that.
enter my lord here. When my juniors were promoted notionally, that is my lord, I filed the proceedings page number 16. Therefore, I filed the OA because OA was disposed 2012. The question of filing contempt doesn't arise at that time. So my request, my lord, it can be disposed of by considering my representation in terms of the honorable tribunal order. That's sufficient.
He doesn't say
Yes,
anything.
That's
because
what
my
I said.
representation it was not reflected. Otherwise, my lord, they may again reject it. Can you see the representative page 27?
Observe that, my lord. APAT order.
Yes, my lord.
In the
That is sufficient.
What was not stated in the representation? What is that point?
That the tribunal order, my lord, on the tribunal order,
Not included, not
not reflected. My lord. That is the basis for my relief. Kindly see the relief, my lord, the tribunal order page number at start from 18.
page 28 of the petition, my lord, wherein the petition filed the representation. He had read that OA order also.
pay half fees to him. He is also arguing on your behalf.
Last may dispose of in terms of this.
28, this is only.
Page 28, one more, yes, my
So
lord.
this
That's
is.
there, my lord.
Strictly in terms of the arts of the honorable tribunal. Otherwise, one could case they may reject it. During the time. below the yeah.
No, G.
G method.
Last para. Page 4, last para.
Yes, ma'am. What the names of party was confirmed. That is
That is the thing, my lord, where he was under currency of punishment. That's what they are not included in 11-12 panel.
And find that question is 21.
He already retired.
He retired.
He retired. And similar that proceedings manner, which can be found at page number 23. 23 manner.
Yes.
That is manner the serial number 1, 3, 4, and 6 are juniors manner. To the petitioners. I find the senior list also. They are already promoted as a Tahsildars. They given deputy Tahsildar from 1/9/2011. Whereas I got 2013 manner, unusual course. Therefore, I am also entitled 1/9/2011 in light of the satisfied in the constitution. All these are juniors to the petitioner.
Only notional.
Actually, lost time only. They will get only the enhanced pension.
Pension 2 years that too, my lord, limited period. 11 to 30 now.
And it is cause of again. That's what I didn't objected for that ballot.
On set side, my lord, is bound to consider. The punishment is set side. The other is bound to consider. Other copy replaced, other copy replaced.
Item number 10, S. Jagdish, GP for services 2.
Fine.
Not fine, madam. Services 5, 6, social welfare.
In case now counter is almost all cases. See, some cases you are in a home and other 1 and 2 there. Some cases counters are there, but all in social welfare no counting is there.
But we have addressing the letters of.
The ultimate result, what is the ultimate result?
Issue people not able to pass. But it's sometimes what is the available at the office on that class.
For want of counter, there must not, there may not be appearance. Honorable Supreme Court has can be decided on the material discussion. Grant 2 weeks style, I'll inform the concerned GP also.
The matter of.
Was there, she was there, only seeking time because counter is not there. Okay, 22nd, 22/11, finally. Also for Krishna Kaji, you are for?
Petition council.
Also Krishna Kaji. Is one GP, AGP for the.
C. Srinivas Baba, GP for services 2.
22/11. Yes. Monday is Monday.
The punishment matter, my lord. After retirement, punishment was
Counterfeit?
additional.
Counterfeit.
Yes, 50% cutting pension was imposed. Last time, last occasion, Judicial Council informed that ballot that they have recorded the amount issues misappropriated, discharging a duties.
The record.
But they have to say on that aspect. My understanding is that she has committed the mistake. He accepted that also. Rightly, we have imposed the punishment 50% cutting pension.
What remains then? What remains in the resource?
And Judicial Council pointed out that there is a lapse of Rule 20 of CCA rules, my lord. On that I said, my lord, if that is the case, it has to be remanded back to the authority to start the inquiry from the lapse stage, my lord. But petition informed that she is age-old lady.
Correct, but procedures are not followed properly.
According to him, is not procedure at all. We have followed everything. We have issued the explanation also submitted.
28/11. 29/11.
Oh, bless.
29/11. The request of same connected. Different. Item.
16.
Same connected. Different.
Bucket is same, my lord. The department is different.
Srinivas Baba.
Wait. Item 1.
Yes.
The request of
Zakir Ali Danish.
yes.
On the European Council on Record again. The Lordship will file this writ petition challenging the mainly 3 proceedings dated 21/4/2004, 29/4/2004, and 13/6/2005. Your Lordship. They also challenge other memo dated 13/2/2017. Your Lordship, the substance of the case is
One second. Who is appearing?
but the notice has not been served on unofficial list. Your Lordship.
Counterfeit.
We have to. After filing counter, there was some development because of the cycle. This employees allotted from the EP discounts to Telangana. Then 13/2/2017, the integrated provision seniority list loss is effective because of the revision of the entire seniority list. And the petitioners were promoted somewhere in 2000. 2009 and 10. Therefore, my lord, the issue relating to proceeding dated 13/2/2017, loss is effective.
But
Official respondents also direct them to further serve notice because
but they will be affected by any order passed by this.
no, this honorable court did not pass any orders.
No. Suppose if any orders are passed, then the unappealable response will be affected.
No, my lord, according to me, my lord, in view of the revisions, neither the petitioners nor the unofficial respondent are affected. I have to mention this honorable court dismissed the MP and no interim orders were passed. If anything to be heard and passed, my lord, then the unofficial respondent will also be heard.
Whatever notices.
As per my instructions, been told that we've been trying to contact the petitioners with regards to the promotion, whether they have received or not. And they have not contacted or replied back. So I seek 2 weeks time to seek instructions from the petitioners.
And in the meanwhile, you also have to take notice on the unofficial response. If you are not served, then you can't take up for even
Responded starts from my lord.
3
Till 15.
3 to 15. Also, Commissioner, request time for taking instructions, further instructions with regard to promotion system of filing application. Conduct system 29/11. You also take up notice or you want this further?
Can I take a short password and seek instruction? Lordship is.
Provided,
In any case, my lord.
provided to suppose grievance is not, the cause doesn't survive, then we
In
will
that case, my friend is asking for password. Lordship can ask.
just check out. The
Seek a short password lordship and seek instruction regarding the notice.
Item number 13, D. Lingara GP for prohibition and excise.
2 weeks time, but counter not filed.
What is the case?
Training for release of pension and pension benefits. They have paid only provision pension. Subsequently, whether they have
Okay, charges for same. Extra proceeds also there. Those proceeds are. How much time?
2 weeks.
24/11. The request of Councilor Krishna present.
Prohibition excise GP for services 3.
What is the petition of fathers and what is the putting regarding the petition of father? Get instructions.
What happened to recommendation, direction to consider recommendation with 5/2017?
Get instructions next week.
What is it?
Next week, basing on this interim orders, is the recorded of.
Councilor Krishna, absent, no request for Councilor Krishna. It is not there.
Item number 15 K Vasudevareddy V Umadevi GP for services 1.
Please file.
Counter file,
Taking it directly.
counter file or not?
Follow that.
Counter is file. What there is a record. On this 1 to yes.
Please file. Follow the rule of delivery.
Counter is there. Yes.
The J. And now they file counter. Para 12 days, they disclose that petitioner was already promoted as junior accounts officer on 1/3/2019.
Nothing serving. Come.
We got this and may pass on the top.
And this same counter.
Very good.
Same counter.
There are 12 minutes. There are 12.
Same counter is also with me. Come. The matter taking hearing. The position of
Number 16 D Balakishan Rao GP for services 1.
May please, Your Honor. So yesterday's matter, this is a covered matter. Supreme Court judgment is there. Persons who are possessed the qualification from BA Ambedkar University, his subject was to be considered for appointment to post of secondary teacher.
New matter contains.
Supreme Court judgment.
Yesterday, GP requested
Consent.
Even I could not find in Lordship until also we have already checked it.
taking time.
Is there अभी one set of copy Your Lordship Wednesday Your Lordship may come date में.
Total bundle.
Yes, not only judgment which they are relying upon. Only that copy.
So Balkishan Rao, you want, he is requesting for the copy to be supplied. The Supreme Court judgment referred to by.
Well, today I will communicate the copy to the government. Period. You will take up tomorrow or Monday, Tuesday.
And Wednesday Your Lordship may come.
Wednesday, Monday is holiday, so it is no problem. 15/11, supply copy. Council President present. GP for services on the request time. To verify.
File that order.
Verify. For services.
In fact, when along with the affidavit, I filed the copy. IA, along with IA, I filed the judgment copy.
Yeah, what else? Yeah. This is done. Not there. I think it's not on record, Mr. Balakrishnan. You have noted that citation. No, you have noted that citation. What is citation?
In the citation.
Will also not Mr. Balakrishnan Rao. Not there. Verify it can get it. It's not there in record. It's for the 31st time. Verify. Fine. Hey, Mr. Ram Kodeshwara, you are ready?
Petition finally posted next week. Next week.
Counter already there on record.
Yes, sir. Counter is already there.
1811. No reference for the council for business.
Item number 18 names recall GP per home. B. Maheshwar Reddy.
What subsequent? What are subsequent developments?
The application has to be promoted for the post of deputy sub-inspector emotion, but has to be brought on record out. And to find the form.
GP. What? The only has to verify whether he is promoted or not. Promoted.
Have to
Just saying, he also letter. He also verify. Survives or not? After 6 years. Suppose already promoted. Then request of council president.
So at the request of petitioner, I will have agent.
Request of council president. Accepting. State.
Item number 19, Ramu Nallamotu, M. Ramgopal Rao, GP for School Education, D. Balkishan Rao.
GP eligibility. Change locality eligibility. This is 2 weeks eligibility. Not pertaining to Tech 2017 eligibility.
You file counter is filed or no? Counter is already there. Counter is there.
2 weeks in.
They reported that Council of Krishna appointed GP. Government leader.
Item number 20, T. Krishna, GP for Panchayat Raj, P. Padmareka, R. Padmareka.
One big time. Water is also fine.
Counter filed.
Petition was not given. He qualified for that post. Regardless of the petition, he was not given the appointment on contract basis.
No replacement of Krishna on behalf of Krishna. Eighteen 11.
Item number 21, K. Satyanarayana, GP for Services to P. Kishore Rao.
Yes.
Payment of salaries. Those salaries were not paid. The petitioners. The last case was filed. Last occasion, so motively implemented the DPO and other concerns. The Panchayat Secretary and other concerns. Notice were received by them. I have received the instructions. Only one copy with me. So please may be taken. Produce 2 copies. In fact, we have complied the orders with the
Complaint.
salaries were also paid to the petitioner.
Not paid. In the year 2013, the Panchayat Secretary addressed a letter to the District Panchayat Officer stating that the petitioners salaries were not paid. 8 lakhs 44,770 and 4 lakhs 33,000 rupees. And also, whoever disposed of the letter, directing the respondents to compare to pay the due salaries to the applicants within a period of 8 weeks.
So far, I have an instruction. I will produce a copy. I have 1 copy only.
When do you want?
Statements, everything is there.
You also give a copy to him because of
What I'm asking
1511. No, you also take copy. 1511 post.
Please.
Is a request for
I apologize.
Council of Krishna Project. EP for services to request time to place on record.
Item number 22, P.V. Ramana, M.V. Ramarao.
52 and 54 filed by the same petitioner. Mostly 2 government orders. Both the cases, the respondent, even after lapse of 10 years, they have not filed counters. But Melody, your assist my grant time to file counter, otherwise I'll proceed with the matter.
The OA of 2013. It's like 10 years exactly.
Petitioner husband died in 2011. After death of the petitioner husband, the recovery proceedings were passed by the government. In fact, we have the proceedings against the moment the person died.
2 weeks finally. No further than
54 also.
Consultation present. Request time to file counter. No further than
54 hours.
54 hours. 54 also same. 54 also same.
54 also by the same person again. It is similar. Recovery after that.
54 documents.
Item number 23, P. Veerabhadra Reddy, GP for Services 1.
Okay. Out of 5? No. Let's counter it. What about petition?
Last section also say petitioner to return time to stating that options have been opted for. Para 7 we have stated how done is that.
This year they will take steps to regulation order. We proceed or we want?
Petitioner counsel is also.
Distinct from council. I know the issue.
Item number 24, K. Satyanarayana, MD Ramarao.
Last edition, you are saying. Last edition, the matter, man missing case. The prisoner is taking branded. As per section. Not yet of the counter also filed that on 17/2/2023, I filed list of citations also. Earlier, my lord, Honorable Justice M. Savakumar garu was pleased to heard the matter and directed us to file amendment petition. That was also allowed last time. Counter also filed. The family pension.
Lordship may kindly grant me next week.
Right. Not well.
Lordship, I am handicapped with a burden. Next week, filing your restrictions.
Substitution also my amendment status.
Oh, she has taken to get the latest. Oh, she. What's counter this? Counter file?
Yes, counter file.
Yeah, okay.
March 2/3/23 counter file.
Counter not that record.
Counter file 2/3.
Not. My account is good. Please. 16. 11.
No, finally.
The request council office to present. The request of the DP for services. First and 16 11. Finally.
Item number 25 to 28. Afiq Ahmad, Deputy Member, Mughali, PS Prabhakar Reddy.
Routine matter, at this stage vacated. Be that as it may, this is for final hearing, it's a very short issue, but I'll proceed with it.
Yes.
The petitioner was doing business in footwear. Now the business is also closed. The 4 writ petitions are the 4 persons who were working in that retail outlet of footwear. Since it was running into losses, they were paid certain amounts, each one different amount. And then they were asked to say that we cannot do further business, we are closing down. So they voluntarily submitted their resignation voluntarily. Then thereafter they invoked the jurisdiction of the industrial tribunal. Despite the fact that section 2A2 says that you should go before the conciliation officer first, and then if it fails, then it is to be gone there. Now the tribunal says pay 2 lakhs each. I'll read the award. The tribunal does not take also into cognizance the amounts we paid by check to them.
Already paid.
Check amount already paid, number 1. Number 2, what happened is, we have given them checks. The tribunal comes to the conclusion that their resignation letter is subsequent to time. Your relieving letter is early. We gave, unless the check is honored, they will not resign. These are the 2 defects in the order. Please see the order.
Please.
The stereotype order in all the 4. This consideration has not been taken into at all by the tribunal. See the order of the tribunal.
It's 13.
The tribunal order.
13.
Yes. Kindly see. The point for consideration is whether the petitioner is entitled for reinstatement as prayed for. Then point the Honorable Court may kindly see. The contention of the petitioner that the services of the petitioner was forcibly terminated by obtaining his signatures on blank papers, whereas the respondent contended that the petitioner tendered his resignation on his personal grounds. Therefore, question of termination does not arise. The petitioner having received the amounts towards full and final satisfaction, he cannot agitate the same. In the proof, the petitioner examined as so and so, his evidence is in consonance with his pleadings. He got filed relieving letter issued by the respondent. During the cross-examination were marked, which is a resignation letter submitted by the petitioner during cross-examination, which was also. In proof of the case, the respondent examined his evidence in consonance with the pleadings in the counter got so. Then kindly skip that, that may not be relevant. Then the next page, the relationship between the parties is not in dispute. The petitioner contended the respondent is not implementing the minimum wages and have not paid EPF, ESI. This was not at all their case. When the petitioner questioned the same, the respondent bore grudge against them. It is to be noted that it is not the case of the respondent that they paid ESI, EPF, but they contend that they paid minimum wages. The respondent further contended the petitioner has to prove the management has not paid. The petitioner contended the respondent has not paid any amount towards so and so. The burden is on the respondent having admitted the relationship between the petitioner and the respondent has paid EPF and ESI, has not filed any document. Apart from that, respondent is making allegation against the petitioner has to prove the respondent has not paid the amount. It is the bounden duty of the respondent to prove that he has followed the labor laws. Then the petitioner contended the respondent forcibly obtained the signatures on white blank papers, whereas the respondent contended the voluntary tendered resignation for which they settled the amount. It is to be noted is the relieving letter, which is mentioned the management has received the resignation on 21/3/13 and the petitioner was relieved on 4/4/13. This happened because the check had to be honored. Proceedings issued. It is interesting to know the respondent issued relieving letter on 4/4. It shows that he will presume that the petitioner has submitted resignation prior to submitting the same. The relieving letter was prepared. It clearly shows that the contention of the petitioner, the respondent has obtained his signature under threat and coercion. This is some surmise, that's all. It is incorrect to so and so. It is also noted the petitioner's ID was examined. It is astonished to note the petitioner filed a petition same evidence, but after thought he not pressed it and he was examined as management witness. In his cross-examination, he categorically admitted that he tendered his resignation, but the respondent obtained papers on 25/2. Clearly shows the respondent, along with the petitioner and 5 years, including so and so, were obtained forcibly, stating that they tendered resignation. In the cross, he admitted that at present he is working with the respondent. See that. In the cross-examination, he admitted at present he is working. Clearly shows that colluded with the respondent and he has not pressed the ID filed by him. The date mentioned on both the signature of the petitioner and the evidence clearly shows the respondent not only obtained the signature of so and so, and by the hook or crook they made the petitioner as a puppet and supported the management. In view of the discussion and a manner of obtaining resignation, issue shows that the respondent under threat and coercion obtained it. Then kindly see the learned judge relies on 2 judgments and then does not do any mathematical calculation with regard to the amount already paid. Then he says that the respondent is directed to pay 2 lakh. How did he arrive this at 2 lakh? What is the basis? Doesn't take into account. They expect that they receive the checks. Each one of someone 40,000, someone 30,000. This tendered the review. Only on inferences this order has been passed. So we are clear surmise. Yes, labor laws have to be honored and the labor has to be protected. But this is not the fashion in which the tribunal should have dealt with the matter.
There is absolutely no discussion as to how the 2 lakhs has
Yes, absolutely no discussion.
basis for this awarding 2 lakhs.
Absolutely no discussion. In result, respondent is directed to pay 2 lakhs within 30 days. He doesn't even do the arithmetical calculation that when they were relieved, they were paid certain amounts.
It also in fact not be
Yes.
adjusted in this amount.
Has to go back not for redetermination.
What about these 2 judgments referred to by
Because that is where it was held that the discrepancy in payment of wages, non-payment of ESI and PF. But that the judgments on this aspect nobody can deny the fact that a labor legislation is a welfare legislation and all that. The fact remains that the tribunal should have examined all these things and what is the basis upon which it has come to the conclusion directing the management to pay 2 lakh. And it is virtually now there is no business, it's a closed defunct organization. So wholesale, it's a retail footwear. Now the business is also closed.
Yes. What is it?
Therefore, my submission, this award cannot say. In all the 4 matters, same thing. Each person was paid different amounts. And the dates of relieving and the things are different.
Amount is same.
Amount variable.
Amount varies.
Yes, sir.
The part is varying.
Yes.
The respondent is same.
And let me take up my counter that page number 12, I filed my resignation letter. Attached to my counter, the last page, page number 13. To 540, WB 540. Resignation letters were dated 20th March 2013. And signature of this respondent is on 6/4/2013.
So my contention was from the beginning that they have obtained signatures on the blank papers and fabricated this resignation letter.
Hold it letter.
Yes, it clearly shows, but the signature of the respondent is this date on 6/4/2013. And whereas blood they have relieved the respondent on 4/4 at page number 12 of their material paper blood. Page number 4. The relieving letter dated 4/4/2013. What is it?
Page?
Page 12.
Well, it's only.
It's the entire record of filed by the. They have filed two.
Okay, right, and one more.
Running index. One is along with the repetition, one is subsequent.
Yes.
It is dated 4/4/2013, right? When they resigned on 6/4/2013, how can they create this document on 4/4? How can they relieve him on 4/4? The management has accepted our resignation date 23/3/2013, whereas he signed on 6/4/2013, and you have been relieved from service from 4/4/13. The management has decided to pay a lump sum amount of 40,000, keeping in view of the good service rendered by you, and after deducting advance of 10,400. How they arrived this figure? They have not filed any statement.
You are reading which page?
It's page number 12, relieving letter.
Not
22/540, WP 22/540.
22/109. In fact, which matter is it?
540.
540 is the next item.
17.
What's the meeting service? Yes, relieving letter.
Relieving letter. 4/4/2013. The management has accepted your resignation dated 23/3/13, and you have been relieved from service from 4/4/2013. The management has decided to pay a lump sum rupees of 40,000, keeping in view of the good service rendered by you, and after deducting advance of 10,400. He never taken any advance. They have not filed any statements of account for this amount, which you have received from the management. You are entitled for an amount of rupees 29,600. What? How they have this figure? They have not filed any document, which is towards full and final settlement and a satisfaction of their service benefit and check of so and so. Is enclosed here. And initially, I filed 5 IDs. 5 IDs I filed, and one of the petitioner in the ID, he withdrawn the ID, and in support of the management, they have examined the court before the lower court, saying that voluntarily we resigned.
NW3.
Yes. He himself filed ID, alleging that they have obtained signature on white papers and they have given resignation letter. After that, they withdraws the case and he examined as a NW3.
Management, yes.
It's the page 47, page number 47.
Yes.
I will read the chief examination. Right? I submitted initially I jailed service of the respondent in the month of March 2008 as a helper and continuously worked till I gave the resignation letter dated 25/3/2013 to the respondent, requesting the respondent to accept the resignation and to relieve me from the service. I submitted the respondent relieved me from the service while letter dated 4/4/13 and paid a lump sum amount of rupees 40,000, and after deducting the advances, I received check for an amount of rupees 31,150 and I have indicated check. I submit that I gave the resignation letter on my own, whereas in the ID blood it says it is created one. The respondent not forced me to give the resignation letter, and I have received a full and final settlement check along with the relieving letter without any coercion or under any threatening from any unsocial elements. I submit that at the time of receiving the check and relieving letter along with the 5 employees who gave the resignation letter was present and other co-employees who signed as witnesses on the receipt of the full and final settlement. I submitted after receiving the full and final settlement amount and relieving letter. I raised in the dispute before this honorable court, which was numbered as 99 of 30, and wherein I have made incorrect allegations against the respondent, stating that the respondent forced me to sign the resignation letter and forced me to accept the relieving letter and full and final settlement amount with the help of 5-6 well-billed persons, as we have asked the respondent for minimum wages and other benefits. I submit that as I could not get the better job outside, I requested the respondent to give the employment, and the respondent, considering my request, taken me on duty as a fresh and subsequently on my own. I have withdrawn ID on 99 of 13. This is the chief examination. The last week I did the class examination. The next page, it's page number 50.
Yes.
I have filed ID 19 of 13 stating that the management obtained my resignation forcefully. He admits he filed ID 19 of 13 stating that management obtained my signature forcefully. Exhibit W3 is a resignation letter submitted by me to the management. I put the signature and date on exhibit W3. I have received for 31,130 after deductions. The amount deducted from 40,000 was goods purchased by me from the shop. 1 year after my resignation, I have joined in the respondent's shop. I have not mentioned in the petition filed by me in ID 93 of 13 that the management returned me and obtained my signature. It is not to suggest that I am deposing false to help the management. It is not to suggest that along with me, the management obtained the signatures of 5 members on white papers under threat and coercion. This is the evidence of the MW3 blood who has earlier filed ID and withdrew it and is supporting the management now. And all also can list the cross examination of MW1.
Please.
It's page number 21. Sorry. It's page number 37.
Yes.
He is Amit Merchant. And in the cross examination, Lord, he says, it's page number 41. I am looking after the business of the respondent shop in which my father is a proprietor. Neither I am the employee nor owner of the respondent. He is neither employee nor owner. Still, he was examined. Since inception of the shop, I am looking after the business. We have not given any appointment letters to the petitioner. Approximately 17 to 18 workers are working in the respondent shop. It is not to say that 70% are working in the respondent shop. The petitioner used to attend the duties from 11:30 a.m. and work up to 8:30 p.m.
Yes.
That is 10 hours. It is not to say that the petitioner used to work till 11 p.m. Except Ramzan, Ganesh Commercial Day and national holidays, our shop will open. Our shop will open on Sundays also. We used to pay OT allowance during the festival season. We are not maintaining attendance register, salary and bonus registers. We are not providing the ESA and PF facilities to the employees. Though they have engaged, according to them, 17 employees, they are not providing any ESA and PF facilities to the employees.
Yes.
It is not to suggest that when the petitioner insisted the respondent for implementing the PF and ESA and other benefits under labor laws, his services were terminated illegally. The petitioner tendered his resignation in the month of 21st March 2013. I have not filed the resignation letter as it was misplaced. This admission in the cross examination, he says the resignation is misplaced. Now they filed before this court.
They find out what is that. They found subsequently.
Exhibit W2 is the copy of the resignation letter attended by the petitioner. The petitioner knows reading and English, writing English. It is not to say that I obtained the signature of the petitioner on blank paper on 6/4/13 and later it was fabricated as exhibit W2 underneath the petitioner's signature in W2 as 6/4/2013. It is not to suggest that we have obtained the signature of petitioner on 6/4/13 under threat and coercion. It is not to suggest that petitioner do not know reading and writing of English language. I have not filed any document to show that now how I arrived at ₹30,260.
Yes.
I have deducted ₹9,740 towards advance. I have not filed any document to show that the petitioner obtained advance. It is not to suggest that petitioner never obtained advance amount. We have paid salary up to March 13, but I have not filed any document to show that we have paid salary. I am not aware whether the petitioner has filed petition before the labor authorities or the shops and establishment. It is not to suggest that I am not give evidence and I am deposing false. This is a cross-examination of the
Next, further.
and you asked me to see the award passed by the labor courts. After considering the entire evidence and record, the labor court come to conclusion they are adopting unfair labor practice and they have obtained citations on blank papers and fabricated this as a
Is application filed before labor court?
Yes.
What was the relief sought in the?
restatement with full calculation.
Where is that application?
At page number 16. The reason also given by the labor court that why restatement is not granted.
No, the application is not there.
At page number 6.
Which case?
Page number 16.
16 of
It's 22/5 for December.
additional metal papers?
Yes, additional papers.
Yes.
Prayer is at page 20.
Prayer is at page 20, last page.
Okay.
It is therefore paid this honorable court will please to direct the respondents to pay
Reinstate the petitioner to service.
to service by setting aside the termination order dated 4/4/13 under the guise of relieving order with full back wages and all other added benefits and pass the further order service. Instead of restating that, the lower court granted compensation.
Correct, but what is the rationale in awarding 2 lakhs? There is nothing, no discussion on.
If I restate that, I will get more than 2 lakhs.
No, but there should be some ground also some calculation on what basis the 2 lakhs has been awarded.
Yes, 51. The lobby should take the award passed by the labor court.
Yes. Page
number 56. Page number 56. Reasoned order passed by the labor. It is also to be noted that one of the petitioner ID number 1913 was examined as NW3. It is astonished to note that he filed a petition with same amendments, but after thought, he not stressed the ID 1913 and he was examined as management witness. In his cross-examination, he categorically admitted that he tendered resignation on 6/4/13, but the respondent obtained resignation appears to be on 25/2/13. It clearly shows that the respondent, along with the petitioner and 5 others, including MW3, signatures were obtained, forcefully stating that they tendered resignation. In the cross-examination, MW3 admitted that present he is working with the respondent. It clearly shows that MW3 colluded with the respondent after filing ID number 99 of 13 and he was not pressed ID filed by the him. That date mentioned under both the signatures of the petitioner and evidence of MW3 clubbed together clearly shows that the respondent not only obtained the signature of the petitioner under threat and coercion, they also follow up the activities of the petitioner after relieving them and by hook or crook they made the petitioner ID number 1913 as puppet and he supported the management and examined as NW3. It clearly shows that the respondent not only fabricated the document, they also follow up the petitioners in such a way that on one way or the other, the petitioner has to come to their dictations, which clearly shows that it is unfair labor practice for which the respondent has to be punished. In view of the above discussion, the manner and mode of obtaining the resignation and issuing the relieving letter clearly shows that the respondent under threat and coercion obtained the signature of the petitioner on 6/4/13 and created documents suitably with the prior date and examination of MW3 clearly shows that the management also obtained this signature and after filing ID 19 of 13, the management by using illegal methods attracted MW3 in their favor and examined before the court as MW3. it clearly shows that the respondent not only after the signature of the petitioner under threat and coercion, they also wanted to use MW3 as a tool to defeat the claim of the petitioner. This is the reasoning, this vindictive tactics used by the respondent clearly shows that they wanted to show their supremacy as an employer, which cannot be encouraged.
Cannot be
encouraged. The manner and mode of obtaining signature of the petitioner and converting the petitioner's ID 1930 as an approver to safeguard the interest of the respondent clearly shows that even this court order for reinstatement of petitioner, respondent will not allow the petitioner to do their job peacefully.
Yes.
That is the reason, Lord, instead of reinstatement full back wages, some combination of 2 lakhs was granted.
That's not.
And my friend says on the section 2A, we have to go to the cancellation of the under section 2A2 Millard, directly we can go to the labor code. There's amendment of the DP government long back. Section 2A2 Millard. Idea.
Yes, wait.
Section, I will read section 2 about dismissal, etc. for an individual workman to be deemed to be an industrial dispute, where any employer discharges, dismisses, retrenches, or otherwise terminates. As my case is not comes to otherwise termination. The services of industrial workman, any dispute or difference between that workman and his employer connected with or arising out of such discharge, dismissal, retrenchment, or termination shall be deemed to be an industrial dispute, notwithstanding that no other workman nor any union of workmen is a party to the dispute. And section 2A2, this is amendment.
Yes.
Notwithstanding anything in section 10, any such workman, as is specified in subsection 1, may make an application in the prescribed manner directly to the labor court for adjudication of the dispute referred to therein, and on receipt of such application, the labor court shall have jurisdiction to adjudicate upon the matter in the dispute, as it is where a dispute referred or pending before it in accordance with the provisions of the Act.
The date of amendment, what is the date? Date of amendment.
Amendment is below 1987.
Right. That's not.
Therefore, this labor court, after going to the entire record for the reasoned order, it appeals on court to dismiss it.
Is it? What is it?
But pass on to his judgment tomorrow.
Pass on to court of.
I saw the cap.
Good light.
Please up. Please up.
Item number 29, N. Ramesh, CP for School Education.
Monday is online. Tuesday, Wednesday. Request of AGP for services 1. 2. Further instructions. Instruction only with your latest question. What is it?
In fact, for this matter, with regard to appointment of the appointment as secondary grade teacher. So, she was selected in the 2008 TSHC by virtue of the respondent start considered, she approached the tribunal allowed the OA, and they approached the Honorable HIGHCOURT confirmed the judgment.
Yes, sir.
He was appointed in 2013. In this case, I am seeking notional seniority.
Notional seniority from the date of order or from the application.
In fact, the apprentice system also subsequently that is the system is abolition. Total is 5, count is 5.
Right. Request of AGP services. Verify the 1611.
Item number 30, K. Anantrao, MB Ramarao.
May I please your lordship?
Yes.
Lord, this matter was argued by me
Yes. Yes.
day before yesterday, my lord, and I had pointed out certain judgments also. Lord, in order of repeating myself, my lord.
No, I've heard that about the police constable who in fact was on poll duty. He did not.
Yes, my lord. Yes, my lord. He fell sick, my lord, and
then he is not taken the sick passport, and then he was with.
Yes, my lord. Yes. Now, my lord, the second aspect was the first contention was, my lord, that for mere absence, my lord, the extreme punishment of removal from service.
You made the 3 points. You made 3 points that.
Yes, my lord, 3 points.
That is not well. He was posted on poll duty.
Yes.
Only for minor absence, he can't be given that major penalty.
Yes, yes, ma'am. The second aspect was, my lord, that after the inquiry and in the order being passed, my lord, by the disciplinary authority, they have taken my previous punishments into consideration to aggravate the burn. Here, my lord, I rely on the judgment of Justice L. Narasimha Reddy.
That is all we have seen already. 2015.
Yes, ma'am. Here, my lord, at para 6, my lord, I will read one para for your lordship, my lord.
Yes.
Para 6 of the judgment. I will pass on the judgment, my lord, by the evening. That is, the citation is 2006 2 ALD, my lord, page 385. My lord, here, in the order of removal, the respondent referred to earlier instances of absence of the petitioner. Here it is to be noted that in disciplinary proceedings, the past conduct of the employee is taken into account to examine whether there exist any extenuating circumstances in the matter of imposition of punishment. In other words, where the outcome of the inquiry warrants imposition of a particular punishment, the past conduct can be referred to see whether the proposed punishment can be reduced in any manner. The learned judge, my lord, observed the past.
No, the AGP is not there, so I'm just passing over.
My lord, instead of pass over, my lord, I have a doctor's appointment, my lord. Kindly.
Which date?
14th, my lord.
14th is a holiday.
14, my lord.
15, 15.
16, your lordship, may say. 16.
Because of the project, at least the AGP process. Request of Council Boston 1611.
Much obliged.
Item number 31, K. Lakshmana Raju, GP for services to.
Who is applying for?
I'm ready.
Ready?
Order is fine.
Yes.
She is seeking as Assistant Commissioner Endowment promotion.
Promotion matter, Mena. The original Mena. Two petitioners, Mena. The OA challenge Mena because the administrative tribunal. Mena, GOMS number 245.
1 second. There is so many counters.
Counter filed with the Mena.
Counter update file.
Reply filed.
4/10/2023.
4/10/2023 from counter.
I filed a reply.
1 second, 1 second. And then 5/10/2023, what is the reply? You filed reply.
One IA minute, pending minute.
IA 1 of 20, what is it?
Grievance minute.
No, what is IA?
IA minute, promotion minute,
Responding to conduct DPC for the final year 2016-17.
without conducting the minute. 05 minute, 5/1/2016, after fabrication of the state.
Yes.
05 is commence minute. 05 minute, my prior minute, page number 1. IA minute.
IA?
IA.
The two IAs, one is IA number 1, IA number 2.
One IA amendment minute already ordered. Direction petition minute, IA.
123.
Good answer.
There are two IAs.
One is the amendment, another is the direction.
I number 1 is to conduct direction to conduct DPC.
May I read, madam?
Yes.
To present to director responded to conduct the DPC for the calendar year 2016 and 17 under revision under DPC for the calendar year 2017 and 18 and consider the case of the petitioner for promotion to the post of assistant commissioner of enjoyment with reference to ACG case as no such proceedings were pending or initiated during the above period pending disposal of the above expedition, madam.
What about IA2?
IA2 will not amendment, madam. Amendment are also ordered.
Ordered. Not ordered. Okay. 15/6/2023 already. Right. Yes. Yes, sir.
After fabrication of the state, madam, the state government might issue GOMS number 5/1/2016. We had a capital search, madam. Enhanced. 3:4:1, madam.
Yes. Yes. Yes.
Capital search, madam, and GOMS number 5, madam, page number 5. IA, madam, page number 5.
IA1 or 2?
Page number 5, madam, IA.
No, there are two IA1.
IA1.
Yes. Yes.
Page number 5, madam.
GMS 5.
GOMS number 5. Madam, page number 7.
Yes.
Page number 7, madam.
Yes.
Now, first vacancy, direct recruitment, second vacancy, execute as a grade 1. Petitioner working as a execute as a grade 1. Third vacancy, direct recruitment, fourth vacancy, is good as grade 1, fifth vacancy, direct recruitment. Sixth and eighth vacancy, direct recruitment. Is good as grade 1.
Yes.
3:4:1 Miller. After Miller, page number 9.
Yes.
After Miller, UIMS number 5 issued and prepare the senior list Miller. 19/8/2016.
Yes.
Miller, it is a serial number Miller 12, page number 27.
Yes.
Page number 27 Miller.
This is senior list.
Miller, page number 27, serial number 12 Miller.
It's a common provision.
Miller, senior list Miller, executive officer grade 1.
Right.
Miller, further promotion Miller, assistant commissioner of endowments.
Page 27.
Page 27 Miller.
Yes.
Serial number 12 Miller. Petitioner people arts. Miller, first petitioner Miller, already promoted. 2016 Miller. Miller, serial number, first petitioner Miller, serial number 9. Page number 26.
Yes. Yes.
Already promoted Miller, 2016.
Yes.
After Miller, conducting the DBC 2016 and 17 plan year, Miller 12 vacancies average. Out of Miller, 8 vacancies Miller. Executive officer grade 1 promoted Miller. 12 vacancies Miller. Miller. Page number 29 Miller. Page number 29 Miller.
Right.
Miller. Reference number 2 Miller. UIM number 5/1/2016.
Yes.
Miller, out of 12 vacancies Miller, only 11 vacancies filled up. 1 vacancy Miller, ST vacancy carry forward 2017-18 family year without filled up the ST vacancy. Miller, first vacancy Miller, executive officer grade 1, second grade 1, third grade 1, Miller, fifth grade 1, Miller, fifth vacancy Miller, present Miller, first petitioner also consider Miller, 2016 and 17 family year. Sixth vacancy and Miller 8th vacancy.
Yes.
Miller, without Miller considering the Miller second petitioner, my junior Miller 2013, direct equity, consider promoted 2016 and 17 family. Miller, serial number, page number Miller 27, serial number 20. Senior list Miller.
Who is the junior was considered?
Miller, R. Sunita.
Is junior to
Serial number 9. We are seen it in serial number 20.
Is direct security.
Direct security, my lord. 2030 appointment. My lord, petition, my lord, to 2011. Junior to me.
Petition number, second petition, first.
First and second petitioner, my lord, same year, 2011.
Yes.
Already considered, my lord, first petitioner. Serial number 20. The senior promotion list, my lord, serial number 9. My lord. Serial number 21. Serial number 10. Both are direct recruitment, my lord. SC candidates. Junior to my lord, second petitioner. Without considering, my lord, 12 vacancies out of total vacancies, 12 vacancies, without 11 vacancies, consider.
No, as per GO5, there are 43421. That is
3 direct recruitment, my lord. 4
from the existing executive grade.
Promote is executive grade 1.
She has come in the executive direct executive cadre. Sunita is direct executive. So she can't be any equated to your petitioner. She is coming under direct security. You are in fact
promoting. 2011, my lord. I am 2011, 2013. 2 years later. I am the senior.
You are senior, but as per GU, 4 from promotion, 3 from direct security are appointed. So in the absence of any senior, then 13 can have been appointed.
8 vacancies, my lord. Executive officer grade 1, 8 vacancies.
Yes.
My lord, as per rule of reservation, consider more than 5, 1 vacancy. My lord, in this case, my lord, 2 vacancies consider SC. 1 vacancy, my lord, ST carry forwards 2017 and 18.
If these Sunita, if suppose Sunita or Sulochana, they are not considered your client, your petitioner will be promoted or benefited from that. See, suppose if say Sunita and Sulochana, they are number 9 and 10, they are not considered. The petitioner will be considered.
Considered. Even my lord, ST vacancy not carry forward. I am entitled to the 16 and 17 family year. Immediately, my lord, second petitioner, my lord, file my lord reputation.
Yes.
Page number 34, my lord.
Yes.
Page number 34.
Yes. Yes.
May I read it?
Yes.
Yeah. Karmangar Samansa, my lord. Ali Kayan Samansa, my lord. Sahai, Parvati, Aviyardana. ప్రస్తుతం 5 డైరెక్ట్ రిక్రూట్మెంట్స్ వరకు ప్రభుత్వం తమలో లేఖలు రాసినారు. ఆ విధంగా చూసుకున్న 2 పోస్టులు ఉన్నాయి. అంతేకాకుండా PO అసిస్టెంట్ కమిషనర్ అండ్ సంపర్క సార్లక మేడారం ఈఓ పర్యవేక్షణ ఫిబ్రవరి 17 కలదు. ఆ విధంగా చూసుకున్న ఒక క్లియర్ వేకెన్సీ రాగలదు. 16-17 ప్లాన్ ఇయర్ లో నన్ను రిజర్వ్ క్యాండిడేట్ గా ఆమోదించి ఉన్నందుకు దయచేసి నాకు 28/9/16 నుండి సహాయక కమిషనర్ గా పదవులను కల్పించారని మరియు ప్రార్థించుతున్నాను. After submit reputation medal, the third correspondent medal issue memo, page number 36.
Yes.
Page number 36, madam. With the reference with reference to above, the individual is informed that he has to wait for his turn in seniority for promotion to the post of assistant commissioner of, since no area market vacancy is available to his federal category during the plan year 2016 and 17. 16 and 17 one ST vacancy, tier vacancy, carry forward 2017 and 18 plan year.
Yes.
Good. Category clearly admitted. Third respondent.
Right.
Clear vacancy carry forward ST 2018 and 19 plan year OC consider. Without conducting the DPC 2017 and 18. 17 and 18 conducted the DPC. I am for entered for promotion. Without conducting the DPC, my proposition is defer. 2017 and 18 plan year.
Yes. Next. The petitioner number 1 is already promoted. There is no problem with petitioner.
He is already promoted.
First petitioner already promoted. There is no dispute.
Yes. Right. Next.
2000, page number 39.
Yes.
Page number 41. Page number 41. 4 vacancies. Erase. 2016, 17 plan year, 1 vacancy. 17 and 18, 3 vacancies, 4 vacancies. Without conducting the DPC 2017 and 18, 2019 and 18 and 19, DPC conducted considered my juniors. 4 vacancies. Page number 41. Page number 41. 4 vacancies. M. Mahendra Kumar,
Hemant Kumar, Surendra, Vijay Ramarao.
they are executed as grade 1.
Yes. They all are seen junior to you?
All are junior. Page number 27. Page number 27.
Why they were transferred?
Page number 27. Tier number 30, 14.
Sixteen.
Tier number 13, 14.
16 also.
Vijay Ramarao, there is no senior list.
Yes.
Further, my juniors.
Right. Right.
Third respondent file counter. Immediately, 2 persons is my juniors. Chara 6. Counterfeit with the third respondent.
The counter. Permits me. My friend is arguing my count first.
Yes, let him say. That's all.
Para 3.
Yeah, no, there was one judgment, Justice Sharath, what is this?
In the meantime,
He also, the second petitioner filed one writ petition earlier, 2023.
Yes, sir. Recently filed 23.
What is this writ petition?
2019 DPC conducting the DPC. Second petition ACB track. Suspended reinstate the service. In the meantime, during the pendency of criminal case, every dishonorable court, my juniors promoted. Same date, I consider promotion. I find the writ petition number 191 of
23,
page number,
page 45.
45 minutes.
Yes.
47 minutes prayer minute. Prayer minute.
Yes.
Issue applied so minute declaring the
Non-considered case,
respondent
petition promotion.
is not considered the case of the petitioner for promotion to the first time after commission of vendors solely illegal, arbitrary, unconstitutional, violate of the 14th system of
That's
and subsequently directly respondent to consider the case of the promotion with all constitutional benefits from the date that which 10/7/2019. I am present case whether 2016 and 17 and 18 plan year. I am for entity. I am for eligible for promotion without any remark.
What happened after this? There was direction to the department to.
We have passed an order deferring his case, proceeding dated 16/8/2023, wherein we have deferred his promotion.
Only pending criminal case.
Because ACB case is pending.
Only pending case.
Pending this writ petition, old writ petition filed that.
Case is pending. Yes. Right. What do you say?
Correct. Okay, paragraph
Judgment of Honorable Supreme Court, Honorable High Court of AP, 11th single judge criminal case pending, dismiss the writ petition. After find writ appeal, set aside the 11th single judge order, allow the writ appeal, consider promotion.
Notwithstanding
Judgments.
Notwithstanding pendency of the criminal case.
257, June 257, there is no application. Consider promotion. I find may reflect.
Yes. Yes. Yes, let him submit. Let me see.
May reply, page number.
33 onwards.
Page number.
Page 33 onwards, you have filed 5 judgments.
Page number 10, page number 10, DPC 2016 and 17. One vacancy carry forward.
Yes.
Seat number 5, ST vacancy.
Yes.
Non-availability, due to non-availability, candidates
Suitable candidate.
carry forward to the next plan year. 2017 and 18. 2017 and 18 without conducting the DPC.
Yes. Yes.
Page number 13. Page number 13.
Yes.
DPC conducted 29/6/2019. Before suspecting, after DPC conducted he carry forward vacancy my junior promoted. Page number 17.
Right.
Page number 17, middle line, page number 17, 33 ST. This vacancy was available in the year, in the band year 2016 and 17. Error mark for ST has been carried forward in the subsequent year. The second year also, that is band year 2017 and 18, no qualified. I am for qualified without consider. My junior will not consider.
This is ST category.
ST candidate will not, OC candidate consider. Subsequent band year. OC.
Who was considered? What is it?
Will
Who was considered?
I am OC.
Here OC. Who was in
Next DPC will not 2018 and 19. Carry forward 2 years.
Yes.
Will not OC will not ST. ST vacancy OC consider.
Why?
I am for eligible.
No. Who
Without
was,
considering, without.
what is his name? Who was that? The other EO who was considered for promotion? OC candidate. Who is the OC candidate who was considered in your place?
My junior, Mahendra Kumar, serial number 13. The senior test winner, serial number 13.
Mahendra Surendran and then one more. Looks like that you have seen.
Senior, junior to me.
Yes, yes, yes.
2017 and 18 winner, fan year conducted the DPC. I am for entity.
Yes. What is it? Yes, sir.
My judgments Millard.
I've seen these judgments. You consider this.
Millard. One interesting Millard, page number 29.
Yes.
24 Millard.
Yes.
Millard, DPC Millard, 2020. Millard. Page number 27 Millard. 4 vacancies arranged Millard.
Yes.
Millard. Yes, Annapurna Millard, OC. Millard, SC vacancy consider. Without carry forward.
Yes.
Millard. Page number 29
Yes.
Millard.
Right.
One Sheshbharti, my junior, sub junior. Millard, during the promotion period, Millard, suffering Millard, some punishments Millard. Already Millard, 3 increments with retrospective. Millard, appointing authority Millard, issue punishment order. Millard, appoint authority, appellate authority, one and the same. Appellate, filed appeal, appellate authority Millard, satisfied the Millard, appointing authority, punishment order. Consider promotion Millard, Millard, one Sheshbharti, without vacancy, 2023, Millard, retrospective. Millard, I read Millard.
Not
File a proceeding.
The date of 29.
2932. Charges were dropped on appeal. She was awarded with the punishment. She made an appeal to the government.
One is the same. Appellate authority, appointing authority, one is the same.
Dropped to that. He has to challenge that if that's the case, my lord. Having not challenged, he cannot comment on that.
yes. Anything else?
You know, state of Telangana, so and so, my lord. The promotion, Srimati Sheshbharti, executive officer, grade 1, to the post of assistant committee of endowments with retrospective effect 2020. without vacancy, whether 2020 consider retrospectively, whether third junior, serial number whether 13, 18.
Yes, yes. Next.
I has brought the new facts.
Whether Supreme judgment whether 63 page number. Similar submission whether Union of India filed SLP, whether SLP dismissed. Cancel whether promotion whether at the time of vacancy arranged, cancel promotion.
Next.
Whether page number 46. Page number 46 whether.
Yes.
Whether middle of the line whether in such submitters. In such submitters, this court held that the tribunal has rightly directed the authorities to open the sealed covers and if the respondents was found fit for promotion by the DBC to give him the promotion from the date of his immediate junior, so and so was promoted pursuant to orders of the date 30th, 1986. Whether I am for entitled whether 16 to 17 fan year. Without contacting the DBC whether just fan year. I am for entitled. Supreme Court whether said so. Cancel promotion whether 1986.
Yes.
Whether page number 51.
Yes.
Whether division between whether the Chief Justice of whether
AP.
AP High Court whether also consider whether page number 58. Is written allowed to allowed whether. Then single judge whether dismiss the pending criminal cases. Whether filed writ appeal. Writ appeal whether allowed subside the whether not single judge order. Then page number 68 whether.
Yes.
Page number 68 whether. Same whether. Writ dismissed. Whether petition allowed whether government filed writ appeal. Page number 68.
Yes.
Whether division bench whether the Chief Justice under having whether DVV Swami Aglo. Whether the state whether filed writ appeal. Whether page number 72.
Right.
Accordingly, whether writ appeal dismissed.
Yes.
Whether again division bench whether to page number 73. Whether similar submissions whether senior whether some allegations there whether promotion not considered, junior considered whether immediately filed whether OA whether yellow consider promotion whether the date of eligibility. Whether the government filed whether writ appeal. Writ petition whether exists whether original OA.
Yes.
Whether writ petition whether dismiss.
Yes.
Whether page number 75.
Right. What do you say? Come.
Makes everything. I confine my counter itself. Para 3 of my counter, wherein we are specifically This post is governed by the rule issued in GOMS number 245 dated to 8/5/2002. Yes, sir, which we have adopted after Telangana formation under GOMS number 5 dated 5/1/2011. Para 3, wherein we have shown the method of appointment to the Assistant Commissioner post manner. That is cycle points and 9 vacancies. The tabular form is there, page 3.
Yes.
Four categories are there. Method of appointment for Assistant Commissioner post. By direct recruitment, first one, second was the promotion from executive officer grade 2. Wherein the petition is concerned with the second one. For para 4, kindly consider the cadre strength at that point of time during 2016 and 17. We have shown in the para 4. It is submitted that the petitioner herein belongs to the feeder category of executive grade 1. In the year 2016, the DPC met on 17/9/2016 for selecting the candidates to fill the post of Assistant Commissioner for panel year 16-17. The cadre strength of Assistant Commissioner is 27, and out of 27 posts, 19 vacancies are there. Cadre strength is 27, but vacancies are only 19. Out of which 12 vacancies are earmarked for promotion, oblique appointment by transfer, and remaining 7 vacancies meant for direct recruitment. On proportion, said 12 vacancies among three feeder categories as per cycle prescribed in GOMS number 5 dated 5/1/2016. The vacancy earmarked to each feeder category as detailed below. First one is executive officer grade 1, 8 vacancies. For superintendent Mofassil 2, assistant executive officer 2, 5th paragraph. It is submitted according to the DPC after going through entire records recommended to promote the following candidates to the post of Assistant Commissioner White proceeding 17/9/2016. Because they have given us 11 names. It is submitted that the petition number 2 herein could not be considered from the feeder category of the executive officer grade 1 since 2 candidate juniors to him, namely R. Sunita and Srimati Aniparthi Sulochana. They were considered under the rule of reservation for promotion to the post of Assistant Commissioner. Though the petition was zone on consideration, could not be considered because of the want of vacancy. Because of the want of vacancy, we have not considered for panel 16-17. 17-18 panel, I have no information regarding that. But my learned friend said that they have not conducted the DPC 17-18 panel. But 2018-19 panel, he is in the ACB case matters. Charge sheet is filed. Because of that, we have not considered 19 subsequent panels also. I submit to that while the petitioner who, while working as executive officer Sri Bedamma Temple, Jubilee, Hyderabad, was trapped by the official of Anti-Corruption Bureau on 7/5/2019, where when he demanded and accepted the bribe amount of 1 lakh from the complainant, Sri Pragya Anjaneyu Sharma, son of late P. Narasimha Rama Sharma, resident of Sikandrabad, as initial payment of demanded bribe of 4 lakhs to take complainant on duty and hand over the orders pertaining to extending the pay scales RPS 2015 to the complainant. The case was registered against the petitioner by the Anti-Corruption Bureau in prime number so-and-so is of ACB City Range, Hyderabad, 7A of the Prevention of Corruption Act 1988, Central Act 49 of 1988, and he was arrested on 7/5/2019 and was remanded judicial custody. The petitioner was placed under suspension on 10/5/2019, and subsequently prosecution sanction order was accorded by the government to the DG of Anti-Corruption Bureau to file charge sheet. Wide GOMS number 42 dated 22/5/2021, and the Anti-Corruption Bureau filed the charge sheet in the above criminal case under CC number 65 of 21, and the matter is pending. Charge sheet is filed in the anti-corruption case So from date for the panel 18-19 onwards, anti-corruption case is pending. He is not eligible for consideration. Now the question lies whether he is eligible for panel year 16-17. We have said especially in the counter we have promoted the juniors. We have admitted that we have promoted the juniors, but they were considered under rule of reservation. It is submitted that the government review the suspension order of the petitioner dated wide memo on 11/7/22 and issue the order to reinstate him to service without prejudice to disciplinary and criminal proceeding pending against him. And accordingly, orders were issued by these respondents under proceeding dated 27/7/2022, reinstating into service. I submit that in year 2019 and on raising of certain vacancies in the cadre of Assistant Commission of Endowment, the Department Promotion Committee meeting was convened on 29/6/2019 to fill up the vacancies in the said category. The committee, after going through the entire records and after considering the fact that a criminal case has been registered against the petitioner, crime number so and so of ACB City Range, Hyderabad, under 7A of Prevention Corruption Act 1988, under Central Act 49 of 1988, and he was arrested on 7/5/2019. And was remanded to judicial custody and also suspended from service on 10/5/2019. Did not consider his case for promotion to the post of Assistant Commissioner Endowment and recommended to promote his junior. Accordingly, the orders were issued under posting dated 29/6/2019, promoting the 4 individuals who were junior to the petition the cadre of Assistant Commissioner in the existing vacancies. Because of the pendency of the criminal case, my lord, he was not considered, and juniors ranging in 4 numbers, my lord, they were promoted. And we have averted the
What about this judgment where the Honorable Division Bench of AP High Court, the pendency of criminal case is not a bar for promotion. Also, there are other judgments where it says that the pendency of criminal case is not a bar for promotion. What do you say?
With great respect to that, my lord, it's only a persuasive, having the persuasive value, my lord. It's not binding us to follow that, my lord. It's a foreign court judgment. It's a foreign court judgment, other state judgment, my lord.
Supreme Court judgment?
We need not follow, my lord.
Supreme Court judgment?
It's only a persuasive value, my lord. So we have to
Court?
follow the Supreme Court judgment.
Yes, that also says that the pendency of criminal case is not a bar for promotion.
My lord, sir, it's a matter of anti-corruption case, my lord.
Yeah.
For that, my lord, we have made a government regarding that, my lord.
Yes.
Even in terms of GO 257 also, my lord, we have made a government in para 10, my lord. It's pertinent to submit here that the government under white GOMS number 257 dated 10/6/1999 issued instructions for evaluation of cases of persons against whom inquiries, trial, investigations are pending and categorized them into following group. An officer with a clean record, the nature of charges, allegation against him, whom relate to minor lapses, have no bearing of integrity or efficiency, which even if held proved would not stand in the way of being promoted. Kindly consider this matter. The magnitude of the charge, man. Second one, an officer whose record is such that he would be promoted irrespective of the allegation of the charges under inquiry, trial, or investigation. An officer whose record is such that he would have been promoted and he had not been facing inquiry, trial, or investigation in respect of charge, if held proof would be sufficient to supersede him. It was instructed that suitability of the officer for inclusion in the panel should be considered on overall assessment based on the record. It should include namely adverse remarks recorded in the annual confidential reports, the penalties awarded, the bad reputation of the officer as was shuffled by the head of the department and the secretary to government to the department of concern. The above cases should be considered as falling under the category 2 of item B above. The officer who do not have any adverse entry in the annual confidential report and who have no penalties awarded against him in the entire duration of the post and not merely the past 5 years, whose reputation is vouchsafed by the head of the department and secretary to government of the department, should be considered as falling under category 3 of item B above. The officer categorized under item 3 of GMS number 424 GAD dated 25/5/1976, as mentioned above, only should be considered for ad hoc promotion after completion of 2 years from the date of departmental promotion committee, screening committee meeting in which their cases were considered the first time. The appointing authority should consider and decide that it would be, kindly consider this assessment, and decide that it would not be against the public interest to allow the ad hoc promotion to the officer concerned, and this should be decided with reference to the charge under inquiry. If the charge is one of moral turpitude, misappropriation, embezzlement, and grave dereliction of duty, then appointing authority should consider as not in public interest to consider the ad hoc promotion to such charge officer. In the present case, the petition was trapped by the official of Anti-Corruption Bureau on 7/5/2019. The criminal case has been registered against him, crime number so and so of ACB matters. And charge sheet has also been filed. The matter is pending. And the consideration of the said facts petition was not considered for promotion to the post of Assistant Commissioner of Endowment. Malad, if Malads are relying on the division bench orders, Malad, but an order of rejection is staring at him, Malad. Because of the Honorable High Court order, we have passed the order saying that it cannot be considered. He has to challenge that, Malad. For panel 18-19, Malad.
That is not challenge. That is not challenge. Next round is not challenge.
That is not true.
The pending
One second,
OA.
one second. That's all you. That's all you.
That's all.
Yes.
Pending OA 2014 filed OA.
Yes.
2019 ACP track. Without conducting the DPC 2016 and 17 and 18, DPC conducted, I am for promoted. Without conducting the DPC, thereafter, DP, ACP track.
Yes.
Page 51, division bench of AP, clearly covered by judgment of 257.
Yes.
Criminal case under department proceedings. There are single judge dismiss the writ petition. Same ground allow the writ appeal. Consider promotion page number 58, para 20.
Yes.
Another division bench. Junior promoted. Pending the criminal department proceedings. When same pending criminal cases.
No, I think there's some Shesh Bharati. I think she was
Yes,
not a pendency. After clearance,
Yes,
she was
Never
considered.
drop the charge.
Before, my prayer is 2016, 17, 18, 19, no. Vacancies available, 3 vacancies, I find retirement vacancies. Page number 21, my reply.
Right.
Page number 21, one vacancy carry forward to the 16 and 17 plan year. 17 27 to 2017, one retirement vacancy. I find reputation. Consider any vacancy, consider. Page number 21.
Yes, yes.
We assure
Right.
Assistant Commissioner and Executive Officer so and so due to retirement. Page number 22. 2018. 3 vacancies 2017 and 18. Without conducting DPC. DPC conducted I am for promoted. 17 and 18 plan year. My prayer is same.
As for 17-18 panel, my friend is saying that DPC is not constituted. Rule 6 of State and Southern provides for preparation of panel for every year. In fact, that rule also provides no need of preparing the panel. Subsequently, they have given reasons for that. For that, I have
2019 one vacancy.
Yes.
2019 one vacancy. 4 vacancies.
Number 59 Tuesday. 59.
What is it? These are
Item number 59 Tuesday.
item 59.
I filed statements without consultation. Without details without mention.
Item number 59 Tuesday.
1 second. 59.
59.
1411 is a request. You are for
For the petition.
inform other side.
Inform the petitioner on coming on 15/11.
Item 70 or 72.
14 and 15.
One second. Let me-
Sorry.
70 or 70. The request of you are for
Respondent.
inform
I have informed petitioner.
request of GP for energy. Question 15. 1511.
38.
Yes.
Respondent.
Yes. Counterfile? Counterfile or not?
quite, that's the answer.
I think you already taken time. You already taken last, I think it was time was already taken.
Finally, they are
17 minutes. When you want? When?
1 week next.
1711. The request of standing council for change. For filing count. No further time will be granted. Finally count file no further time. Next.
14 and 15.
49, 50.
50.
Yes.
Next week, counterfile. Next week,
Item 40 and 50.
next week, immediate. Immediate.
In the request of council, you inform us, GP.
Application now written with several times.
When you're seeking time, you need to supposed to inform.
Like
Say what about
taking
other-
time and complaining on that.
I will inform you.
1811. 1811.
18.
Item number 39, 40.
Request of council for extension.
39, 40.
Yes.
And for the respondent, I thought of the type of for others, like 2 weeks.
17 minutes still counted. Here for? Here for?
For the respondent, picture. Yeah.
Where is Mr. Acharya? When you want?
2 weeks.
2211. Finally, no further time. The request of GP for. You are for GP for. What's your?
For the starting of JH.
Yes, standing council for change. Chandrasekhar Reddy.
Just a round.
Mentioned as Reddy.
Item 32 of your lordship's list below there. Item 32.
GP 21. 22. Finally, no further time.
Item 71, my lord.
Yes,
Item,
Petitioners, my lord. Kindly have it on 16th or 17th, my lord. Next week. 71,
You are for?
petitioner, my lord. I have informed the other side.
Counter file. Item 21. 21.
item 32 of your lordship's list below immediate matter.
Yes.
Item 32.
Yes.
It may be taken up next week, my lord. Last occasion, my lord, the legislature directed me to file an IA.
Yes.
That I was filed yesterday, my lord. It will come up in next week. Your lordship may have it any date in the next week.
1611.
16.
Your Honor. May I, Your Honor?
No mentions, no.
Your Honors, on second. Mr. Court Master.
Only 39 connected.
అదొకటి తీసుకోండి.
సారీ
12
మన ర్యాంక్ ఫస్ట్ పాస్ అవ్వలేదు.
12 పాస్ 32 కంటిన్యూషన్ 33 నుంచి 33
పాస్ అవే ఉంటుంది.
పాస్ అవ్వాలి, ఎక్కడైనా పాస్ అవ్వాలి. ఫ్యాన్ బంద్ చేయరు. బస్ తెలియదు.
Teenage 40 was taken by TSHC from the 31 button attached one. It is a covered match.
No, 39 40 only, not 41.
41.
Actually,
No, 13 40 two.
Password matter item number 12. E. Madhavi, Zakir Ali Danish.
With regards to the service of notice, Your Lordship, I've told you before that we have to make call to the petitioner whether they have received promotion or not regarding the packet. So Your Lordship, as per my instructions, if we do not receive any information, we do not know whether the service of the whether the purpose of the petition is served or not. So for that matter, request 2 weeks time, Your Lordship, to find out from the petitioners regarding the same. And after that, if the purpose is served, we will file notices, will send notices to the official respondents.
Okay. Then first also
Continuation of progress. Item number 33, S. Gopal Rao, GP for services 2.
Matter pertains to regularization service. Was appointed as the but on 8/4/1980. 8/4/2000, 1980.
Yes.
Thereafter, version was 21212.
Yes.
Last occasion, we learned the 7th month passed in order. In fact, the respondents have sent a letter requesting for sanction of post.
Yes.
Directed the respondents to first respond to consider and pass orders on that. Thereafter, they rejected the case. Rejection order is also challenged by me. That the order is already for amendment for amendment of the relief.
Yes.
That is already ordered below on 5/10/2023. That order may carry this. Right along with this, again, 1/2023. Please, 9 minutes, I have 1 hour. But their defense is,
Yes.
their contention is, one is, she doesn't possess the requisite qualification.
Yes.
That is non-passing of 7th class. Another is, there is no sanction. These are the two contentions. But first contention is 7th class is not required to be passed by the post of sweeper as per the last grade service. That goes.
Yes.
And the next is not, even if they cannot take after working for, after extracting the work from me for more than 30 years, they cannot say that there is no sanctioned post, but as is held by the division bench of this honorable court. And the recent judgment is also there. But they said, even if there is a sanctioned post, you are this but this rejection of the mechanism.
Where is it?
As if there is a sanctioned post, they said. That means that.
Which page?
Page 9 Millard filed along with idea 1 of
Yes.
2003.
Right.
But seeking amendment of the relief.
Yes. 5/8/2023.
This is 5/8/2023.
Yes.
So Millard, now she retired also. Pension. Not even a single pay she is getting. Srimati so past tense paper is informed that the Honorable High Court in its orders in WPPR number so has directed the respondent number 1 Special Chief Secretary to expedite and pass appropriate orders for sanction of post of last grade on regular basis and to consider. But this was a recommendation for sanction of the post also. It is required to be sanctioned. To consider a case for regularization of services in terms of service. So, let with service and pass appropriate orders within a period of 3 weeks and communicate the same to the petitioner. The individual is further informed that as per 0212 and also 112, one of the conditions stipulated for regularization of services is that persons appointed should possess the qualifications prescribed as per rules in force as on the date from which her services or her services have to be regularized. But in the instant case, she is not in possession of qualification required for the post of office subordinate
or for the post of watchman in last grade service. But she is claiming for regularization of services in the category of sweeper. Sweeper, my lord, you will not kindly see the last grade service rules, my lord. Last grade, but they thought that I am seeking a regularization for the post of office subordinate, which is not even my claim. But for sweepers, my lord, you will not should get this last grade services, my lord. If the last grade service rules for office subordinate passing a 7th class is necessary.
Yes.
My post, I was appointed as a part-time sweeper, and my claim is also regularization in the category of sweeper. But for sweeper, my lord, you will not will get this. Only must be able to read and write Telugu or Urdu or English or Hindi. That's all.
Rule.
Last grade service.
Rule number.
But rule 5. Annexure, my lord. Rule 5, my lord, prescribes the qualifications as mentioned in the annexure. Rule 5, my lord.
Annexure.
Rule 5 of the last grade service rules provides the qualification.
Volume 2 civil services.
ఇది ఇచ్చేస్తా ఇది తీసుకో ఇది తీసుకోండి ఇది కూడా ఇది ఇవ్వండి మన రూల్ 5 prescribes the qualifications to be required to be asked for the post in the included in the last year service. Includes sweeper also. As mentioned in annexure.
Method of appointment, any method.
Qualifications rule 5 milla.
Qualifications is
Rule 5.
be able to read and write Telugu or Urdu or English or Hindi.
But even the rejection office says she doesn't possess the qualifications as required for the post of subordinate, office subordinate. Attender 7th class, office subordinate 7th class. My claim is not even that. It seems they don't apply their mind. If at all it is there.
With my serious comment, I will say one thing, Madam Sastra.
And the next is, even if there is sanctioned post,
In a way, we have filed a counter saying that there are no sanctioned post of sweepers. The question of observing as a sweeper doesn't arise. That's one thing, my lord. Moreover, my lord, in order of recognition her service, my lord, my friends have said she has rendered 30 years of service. In order to accommodate her, they want to observe her as a office subordinate, but she didn't possess the qualification. And moreover, my learned friend said that
claim is not even that.
Moreover, that
They thought someone
a sanction post, my lord. Honorable Supreme Court in Umadevi said, my lord, there must be a sanction post. And my learned friend is saying that with the rendering of 30 or 40 years of service, that concept of sanctioning post doesn't arise. But very much clear Supreme Court on that aspect.
But a recent judgment of Justice Nanda Miller.
Already a Supreme Court order is there. Ilmodevi case 2022. Very specifically had
all these things were.
See, what is other point you want to make? This is only one point.
But the even rejection order, Miller, what they say, she doesn't possess the qualification as mentioned in the service, last state's service rules. Even if there is a sanctioned post, that is the reason. Do not will get that word in the rejection order.
I will get the revised order of that matter. Gives me permission. By
Yeah.
using that word and wording,
getting.
they are taking the advantage, madam.
Can you now revise? You have passed order. While passing the order, you
Two orders were passed. Earlier, superintending engineer passed, my learned friend is the government has to pass. The government has passed now the order. Now my learned friend is saying that government has passed order saying that it's not the sweeper, it's the superior, it's not the office subordinate, madam. Maybe they're not having the proper record with them.
What? So without going through the record, they.
The landlord has to overcome the concept of sanction post malon.
Okay, then we'll come.
That is also, there is another judgment of judgment clause.
I think it's already there on record. WP 26580. This is Charameshwar and Ramesh.
Yes, madam, that is also there.
26580.
Yes, madam. They cannot take such plea after extracting for years of services from the employees. That is the judgment. I have filed also.
There is already there.
Yes, madam. The para. Therefore, they are saying even if they sanction post, she doesn't possess the qualification. With regard to qualification, rule is very clear. My claim is only to the post of sweeper. Since the beginning, she had been working as sweeper only. They thought I am claiming it, but even the rejection order says for the post of office subordinate. ఏమి ఆలోచించట్లేదు వాడు అసలు.
Therefore, I recommend my senior name to advise the department.
Provided you pay.
My claim is sweeper.
No, provided they pay fee. Provided you pay the fee, they are ready.
నాకు ఇవ్వాల్సిన ఇస్తుంది.
His fee, not your his fee.
Litigation won't come to the court.
ఊరికే ఆవిడ ముసలాన్ని ఏడిపిస్తున్న తప్పలేదు.
Which this is Charameshwar's order. Copy is there with me.
Yes, not a para.
There is no paras. In fact,
Paras not there. Not
page
18.
Yes.
But the petitioner seeks to
middle third and fourth.
The petitioner seeks to take shelter under the said clause to say that there are no sanctioned posts, clear vacancies. The existence of a vacancy is not a matter of absolute discretion of the employee. In a case like the present one, where admittedly the services of the 51 respondents are being extracted continuously for a period of 2 decades. Here 3 decades, more than 3 decades. It does not lie in the mouth of the petitioner to say that there is no clear vacancy of post. The creation of post is exclusively within the hands of the municipality. As discussed earlier, the municipality chose not to create the post but extract the work from these response in an unregulated disease. It cannot be permitted to plead such a defense. And in fact, in recent judgment of Justice Nanda Miller, as mentioned in the quoting the.
What about this judgment? 5819/2018. One more judgment also in fact you please forward.
Nihal Singh said, but in that judgment,
no, this is not.
Post cannot fall from the heaven. It is for the that is the word used in that. But last line is last para 28.
Which one?
This judgment, recent judgment of Justice Nanda. But referring all the judgments of the Honorable Supreme Court.
Okay. Ramesh and others, 5819.
5819.
Yes. What is para?
Para 28.
Okay, okay.
Para 53 of Umadevi Milade, when they have completed 10 years of service, they are entitled. That is.
I think this is reported some other day. Somebody in fact reported yesterday.
Para 28 last line, Millard.
Yes.
Sanctioned posts do not fall from heaven. It is, state has to create. In fact, in this case, Millard, as long back as in the 2000, they have written a letter to the government to sanction the post because it is required to be sanctioned. Therefore, not the Honorable
It is not
Justice,
sanctioned.
Honorable Justice Shravan Kumar directed to pass orders on that. They said now they said they issued the order, impugned order. She doesn't possess the qualification for the post of officer, even if it is sanctioned. But the sanction is not necessary.
Yes, yes.
At least,
Yes,
but
yes.
she has completed more than 33 years of service.
Yes, yes. What is it?
Good lady.
Have you got fee or not? Then
Counter. My friend has got fees, my lord. When she is hearing. But Sahil sir is very kind enough, madam. We have learned from senior only everything. Well, my only endeavor is to record my contention of the counter, madam.
Yes.
That can be recorded past appropriate. In fact, Ilmo Devi case is there, madam. Wherein in 2022, Honorable Supreme Court, madam, I forgotten my bundle of judgments, madam. I give it not tomorrow. Page 3, para 2, madam.
Yes.
It is to submit that NSC O and M Circle Miryalguda, there are no sanctioned post of sweepers and creation of posts. But for regulation of service of the part-time worker members have been prohibited in Act number 2, 1994. Further, she has not presumed requisite qualification as she is not ex-serviceman or undergone home guard training for her absorption to the post of watchman. The government has already rejected. This can be recorded, my lord. So please, I will give the judgment, my lord. That is that Honorable Supreme Court dealt with everything, my lord. On Umadevi case also, my lord.
Yes, in under judgment, he also referred to Uma Devi, Nihansi.
Yes, my lord. But Apex, I am relying on the Apex Court, not the High Court. Apex Court I am relying on. Wherein they have said categorically there must be a sanctioned post for regularization or absorption.
Yes. That's all.
That's all. Last 2 years, my lord, sir, I have a motion with him.
అప్పటి నుంచి ఇది పాపం ఆవిడేమో ఏడుస్తున్నాయి. Directly covered by justice.
Item number 34 and 35, Shantapur Satyanarayana Rao, GP for medical health, GP for services to.
Along with the reply, I published 2 days, I filed 4 cases. For reply, logically, basically.
There are no counters, madam. In fact, last 2-3 occasions I have, last 3 occasions I have taken the time either to get instructions or counter, madam. Just before lunch, I spoke to them, madam. 1 week they are seeking. Because my friend is seeking the setting aside the articles of charge pertaining to 2008, madam, and further promotion to the post of civil assistant surgeon and deputy civil surgeon in another case, madam. Finally, 1 week may be given, madam. For that ballot, in the absence of counter, it may be decided.
Already there, no further time.
I published I filed 4 cases. 2 requisitions were already dealt by the Assembly. I closed last occasion to perennial the same. Along with closed judgments, I prepared and included the topics. Same charge memo, they added 1, 2, 3, 4, like prisoners. Even I also last can you see in the expedition.
Will you wait for 1 week? He also
1 week.
Finally, he said.
I apologize to my friend also, my lord, for that. I'm able to get that section.
We on tenure we recruit together in the same group. But in this particular case is concerned, I know DB is available. The total direction is letter for the department. One of the person is retired employee, he is working since long time. Around 20 cases filed against him, DAB. He is holding the retired employee is holding the post. Around 20 cases were filed to remove his cases, but no one is coming this to. Second one is that if you have faith, that I can I don't have any faith on him. Because every day he is publishing papers. I know that recently, when it is out of court, recently when one of my clients went to, that he is according to me, my client is senior than him. A junior person is accommodated as the director. He went along with the MP.
My learned friend may not go on that. Everyone is watching on that aspect. We cannot comment on a person who is not at all a person in party in this. Let him confirm to these cases. He just requesting for 1 week only, madam. And some 1 week time only, madam. We'll decide on that matter, on that way.
Just page number 41. I know you will be a first girls can ಇದೇ ಪರಿಸ್ಥಿತಿ ಹೇಳಿಲ್ಲ ಸರ್ ರಿಚೆಕ್ recently my client is page 41
compilation.
The position is going to assist on merit of the case also. Because what is also not with me, my lord. If I have to save of my time, my lord's time.
Only wanted to say, I grant 1 week time, not only. We want
by declaring Dr. Gardner,
yes.
The entire action of respond not to receive the on the underwood ground that this very things initiated with charge memo dated 6/12/2018. For the issue 2002-2003. The charge memo is also same date with the same. Only they are added with -8, -9, -1, -3. A lengthy order being passed by this court by relaying the judgments of the apex court. 4 cases I filed, 2 already allowed. See, next one is 65. Page number 65.
Yes.
Same prayer. RC number, date is 196. Several times I argued for a portion of the caption of our orders. Last time when benches are about to declare on Friday, last one about to declare judgment. Unfortunately, the learned judge was on leave. Even the docket shows several observers were meant.
Whenever my friend case is listed, judge has to attend. He is complying.
Well, we had a cover. This call the matters were with the Friday, the job change.
16. 16.
Stage captain last
I apologize.
I apologize. He's also in there.
Request of council.
Item number 36, case the GP for prohibition exercise, GP for services 1 and 2.
Same section. Monday is holiday.
Tuesday.
Ticket type.
Ticket type. Yes. Additional offender is a moderate. Is appointed. One of the candidate name is the more meritorious candidate. That is reverse knowledge class.
14. 14.
Okay.
There is question. Council question.
Item number 37, K. Asad Ahmad, GP for services 5 and GP services 1.
The part of the district officer, petitioners were appointed as a foster welfare officer based on contract basis. And they were continuing the services till 2013, your lordship, and they have been terminated in on February 4, 2013. They were terminated on 25/4/2013, your lordship. challenging that termination orders, Your Lordship. Petitioners has approached the Honorable Tribunal, Your Lordship, and Tribunal has passed orders in favor of the petitioners, Your Lordship, on 11/6/2014. There was a batch of cases, Your Lordship, wherein it has been directed respondents to consider the case of petitions for the appointment in the existing vacancies, Your Lordship, as was done in the similar case persons, Your Lordship, in WP number 24918 of 2011, dated 5/7/2013. After that, the petitioners were appointed and they were continuing, Your Lordship, and the services had not been regularized. And on 26/2/2016, GMS number 16 has been passed, Your Lordship, wherein it is clearly stated that under the orders issued for the adoption of the AP Public Employment, regulation of appointments to public services, the rationalization of staff battle Act 1994 to the state of Telangana, accordingly, para 4B of the state government order. After section 10, a new section is added, namely regularization services of persons appointed on contract basis. Accordingly to section 10A, notwithstanding anything contained in this act, government may regularize the services of persons appointed on contract basis against a sanctioned post in the government, subject to the fulfillment of the following conditions, Your Lordship. There were 4 conditions, Your Lordship. It's a page number, GMS number is at page 36, Your Lordship. And conditions are at page number 37.
Yes.
Para 4, Your Lordship.
Yes.
In the AP Public Employment, regularization of appointments to the public services and rationalization of staff pattern and pay structure Act 1994. A, to order act the words, Your Lordship, can you see B, Your Lordship? After section 10, the following new section shall be added, namely regularization of services of the persons supported on contract basis. 10A, notwithstanding anything contained in this act, the government may regularize the services of the persons appointed on the contract basis against the sanctioned post in the government, subject to the fulfillment of the following conditions. Availability of a post in relevant category in respective department shall be the prerequisite conditions considering regularization. And 2 is regularization may be considered only in respect of persons appointed on full-time contract basis on a monthly remuneration. Your Lordship, page number 38, Your Lordship, para 4.
Yes.
In this, Your Lordship, again the same thing as given, Your Lordship. Here in 2, Your Lordship, in para 4, condition number 2.
The only same continuation.
We are seeking regularization, Your Lordship, because the petitions were on contract basis and they were continuously
Full-time contract basis.
Yes, they are full-time. They were reappointed again in the year 2013, Your Lordship, after the orders passed by the Honorable High Court. They were reappointed again. Often has been tried here.
Right. Yes.
That's
Yes.
take note tomorrow.
Present. Ordinary part. People eligible for service. Oh, you are from home?
Continue 40 June, item number 41. TP Acharya, Typical Services 1.
the covered judgment and that's okay. And it's a Chandrasekhar of family. When they have tomorrow, he was under the impression that this also has been posted along with that in court. It's a separate covered matter. This honorable court.
What, when you want? When you want?
Tomorrow. Is a PH for there is a NMR services to be counted for regular stock.
Tomorrow. Next to that is there tomorrow. Inform me.
Yes, I am informed.
Item number 42.
Concept of question present. And we intend that question is covered, clearly covered by only also the diesel bench and WP 1.5
Madraju, GP for services 2.
Not permit separate ticket. I was told your lordship that you are for the number of my.
Who is it?
Initially, hearing is a suspended a sub-registrar mallet. The suspension order is not filed.
Concept is not listed on behalf of Krishna. If DPO services to 6 times per
He may report to the transport department. During the declared proceeding, he may not be released. That has to be closed down, then only he will be released. I get a later position of counter.
2 weeks.
Yes.
Post time 2311. Matter
Item number
177. Matter 16. 6 times counter or 10 6. Finally, the matter 177. So then, madam, they will be written.
may regularize the services of persons appointed on contract basis against the sanction post in the government, subject to fulfillment of the following conditions. Your also kindly skip. These are the conditions that is not in dispute.
Yes.
Now, third point. Regularization may be considered only in respect to beneficial person working on as on 2nd June 2014. Convention of Telangana State and continuing till the date of proposed regulation. Here, we have rejected the case. Kindly take the last page of the council. Last paragraph. It is submitted that the proposals. You also go to page 54.
Yes.
It's humbly submitted. The proposals have already been submitted to the Commission for Tribal Welfare and always submitted the same to the government for examination and further directions in the matter. The Principal Secretary of the Government of India issued memo number 24 that is 31/2017 clearly stating that C. B. Giridhar Reddy and 9 of the petitioners applicant here are not working as on 2/6/2014 stipulated in GMS number 16 dated 4 and not considered correct. This is a mandatory condition as per GMS number 16. Now coming to the facts of the case.
Yes.
Yes. Here, the petitioners were engaged and working as hostel welfare officers on contract basis with effect from 21/8/2010. Kindly make a note of the date. Engaged and working as hostel welfare officers grade 2 on contract basis with effect from 21 August 2010 in the hostels of Nalgonda district. That is before formation of Telangana state. And they continued up to 24/4/2013.
Thereafter, after that, they will not.
Yes, in the appointment order itself, it was given. We're not saying that they should give their way to the direct recruited candidate.
Your Lordships, I think they had challenged their termination orders and they were reinstated on the 20 June.
5960 is the appointment. Your Lordship, page 59. 20th August 2010 is the proceeding. Recruitment of hostel welfare officers on contract basis 2010-11 order sheet.
Which page?
Page 59 of the council.
Page 59.
15 is appointment one. In the counter.
Yes. 28/20/2010.
5960. And thereafter, they will continue up to April 2013.
Yes.
So that date you lost make a note of it. Continued up to 24/4/2013.
Yes.
Thereafter, they were terminated.
Yes.
Because of giving way to the direct recruited candidate.
Yes.
So they were accepted their termination. Meanwhile, similarly situated persons have approached and asked them, and thereafter that resulted in filing a petition.
Yes.
In that, in the repetition they are filing.
WP number. Page 21 in the repetition.
Your OA also file?
Yes. After that, OA. Then this was filed in repetition was filed in 2011 repetition, you know. Order was passed in 2013.
Challenging the condition.
Yes. The prayer you lodge mechanism, page 21. Please to direct respondents 2 to 9. Not to displace the petitioners from the existing places by giving postings to the newly appointed person pending disposal of petition number 24916 of 2011 in the file of High Court. Now kindly see the order. 22.
Yes.
Kindly turn to page 22.
Yes.
The first two paragraphs is the contention of the petitioners. Now third the learned counsel for the petitioners and so on. Leader for social welfare is absolutely right in pointing out that 3 vacancies of hostel welfare officer grade 2 lying in East Godavari district have been notified among the others for recruitment to the Andhra Pradesh Public Service Commission, which has since finalized. Now the selected candidates have to be issued orders of posting. The selected candidates where should be posted in exclusive subordinated line with the domain of the state and the administration of the resources belonging to the state. But however, this is a consideration of the court. If there are still vacancies of hostel welfare officers left in East Godavari district, the claims of the petitioner may be considered convenience against one vacancy or the other, taking into the fact that they are already engaged on so. It is made clear that the posting orders to the directed to selected candidates cannot be withheld or stopped under any circumstances in as much as they have a right to ask for the posting orders. And this petition is still pending on the file of number 9.
Only one.
It's true. This is still pending.
Still pending.
Thereafter, I don't know why it has come to file before the High Court. Being a service matter, but however, there's an order passed, and basing on these, tribunal passed an order that you ought to find even in the restriction they filed from 66 to 79 onwards in the counter. And what has happened to these lawyers? I was not.
Yes.
66 to 79. I think petition should know better because all these are renumbered as WPTRs. 66
pending and closed what?
That petitioner should say. The lodges that OS has been closed here. When there was a direction.
Only interim order.
Only
interim order.
Interim order. That too basing on the interim orders of the High Court. I could not lay my hands on this because WPTS I could not immediately trace out. Now, the point for consideration if you also clear, the GO specifically says those who are working as on 4/6/2014. And the orders in the way you watch me kindly see that they were given in the month of from June to July. Orders are passed on various dates. Some is 20th July, 11th July, 20th June, 11th June, 3rd July, 27th June, 1st July of the orders. We have.
What is the order cost? What is this?
66 to 79 of the orders.
No, what is this? What is the order for?
Order is referring to the High Court order. Pending disposal of the OA of directed to
consider the case of opinion from one to post of it.
In the existing as was done in respect of similarly person by extending the ratio of the order so and so. That was only an implemented order. But this we have implemented. We have implemented and appointed them again on 28/8/2014.
So that can be said that is continuing or
they were not working on 26/2014. And the language used in GMS number 16.
Correct.
Yes.
They were continuously there up to 24/4/2000.
No, 13. 1 year.
Before 4/2013, they were there.
Yes.
Subsequently, they were terminated. You have to direct equity.
Yes.
Then they filed writ petition. There was intent direction. Basically, they filed OA. OA also in fact directed you. You have complied with. You have not taken any objection with regard to performance. 28/8/2014, you have done. 28/8/2014.
August 2014.
So whether
But the cutoff date is 2/6.
so in between what happened 24/4/2013 to 28/8/2014, that's the crucial period where
They were out of service.
out of service.
The crucial date is 2/6/2014. They were not working.
Correct, but when in your subsequent appointment, it doesn't amount to continuation. That's only problem.
The direction of the High Court is also known. In the existing vacancy, we have terminated. That is not challenged because they do not have any ground also for challenging because that they come their question cannot come in the way of direct recruitment. So strictly speaking, my lord, for implementation of 16, they do not fall within the category.
If they were not in service on
They could
2/6.
not have been reinstated, your lordship. They have been reinstated. That means they.
That's why I pose a question whether that amounts to continuation. Okay. In that intermediate period, you are not there. That's only so that the cutoff date in fact happens to in that intermediate
So
period.
the policy cannot be extended. Your lordship are well aware of the policy. If they fit into the policy, you know, they can be considered.
Yes. Next.
The lordship may kindly consider the termination orders were on 24/4/2013, your lordship. Again, they have challenged the termination orders before the tribunal. The tribunal has passed the orders in favor of the petitioners to consider the case because they were the vacancies were existing. And again, they were appointed to 28/2014, your lordship.
So you are not see only what they are trying to say that you are not meeting that condition which is in fact there in DO. The DO is clear says that as in that the 2/6/2014 who are there in service only can be considered. The contention is that since you are not there admittedly, you are not the DO doesn't apply to you. That's only contention. The 24/4/2013 you are terminated. 28/8/2014 you have been appointed, not reinstated. It's reinstated or appointed? JP.
Yes.
Is it appointed or reinstated? 28/8/2014.
But only to assist the court, my lord. Actually, my friend should bring all this to your lordship's notice, but your lordship kindly say appointment order.
Where is it? Page? Page?
Page 80 of the court. No, lord. May I take your lordship?
Yes.
In view of the above circumstances, as per the theory of the following meetings are hereby re-engaged as outer method of service contract basis in the existing vacancies constantly conducted so and so or any other method. The services, the individuals are hereby continued as hostel welfare officers on contract basis up to 23/4/2015 during academic year 2014-15 only, and posted in the existing vacancies available in the district as shown under. Continued up to 23/4/2015.
They re-engage. So the periods are gone. You are not there in
Re-engagement, it's a fresh one.
that's now.
Reappointment, appointment and reappointment.
That's why a physical or whether reinstatement or re-engagement that that period can't be considered as continuation.
I understand, my lord. Even one more thing also, 2/6/2014 will be always a vacation for the schools and the welfare department. And there is also a clause in the GO that should be ignored. But here it is 1 year, 4 months. I can understand, my lord, if it is only immediate, that would have saved them. In the GO, it is there. For the purpose of continuity, the annual breaks in certain vacation departments like education and welfare departments may be ignored. So that way, they would their services would be terminated at the end of the academic year. Again, they would be engaged from the reopening of the schools. That particular break would have been equal. That is the intention of the rulemaking authority.
Next academic year.
1 year, 4 months gap. And the GOs clearly speaks, regularization may be considered only in respect of eligible personnel working as on 2nd June 2014. This is all my question.
And
Obliged.
Item number 43, Umadevi Nama GP for Municipal Administration, GP for Services.
Yes, yes.
Application of the state Millard. 4/9/2015 Millard, the petitioner transferred to the AP government. In this regard, Millard is in the entire material and the service register and the others Millard is transferred to the AP government. Millard. Petitioner also working in this AP government. Millard now.
Yeah, what remains?
When the offense place in when he was working as a commissioner municipal, municipal. Is
Whether the punishment is still there or what is it?
punishment of stoppage of 1 annual grade increment with cumulative effect for a period of 5 years. And the recovery of
And misappropriation.
2,89,000.
2,89,000. Basing on this Millard is entire.
Now, the state government of Telangana cannot escape by showing the Reorganization Act that the employee has working in Andhra Pradesh. No,
He's only saying that what is subsequently happened.
yes,
He's not saying that he's escaping from what.
he's escaping from liability. That's by showing that the Reorganization Act. A number of judgments are there, rendered by Justice M.S. Thompson and
Yes, what it says.
that liability according to the proportion that can be.
Even the
40 to 58.
Yes.
Even though there is no records Millard, now itself Millard is there.
What?
To the
Correct. In the event, suppose say the prisoner succeeds in the equation.
Even counter itself Millard is preparing the counter itself Millard is
Counter not
difficulty.
He is expressing is the difficulty in preparing counter and filing.
Yes, by taking so
Because there are no records.
and transfer.
After that Millard is petitioner Millard working in the GHMC Millard. At the time of transfer Millard. There is no records in GHMC.
Whatever it is, otherwise you call for the document from AP.
Party to the AP government Millard is transfer. Petitioner is working in the AP government. They amended the
Also make AP 40. So that and just check whether we can make the AP again the municipal administration government of AP if we make 40 then also prescription for it. GP for services. Depend that.
Item number 44, M. Shalini, GP for irrigation, command area, GP for services 2.
Petitioner's father's land was acquired for the purpose of umbrella project. The petitioner filed the OA melon.
Yes.
Petitioner filed the OA melon. The honorable tribunal disposed of the OA melon, stating that if the petitioner's land is adjacent to one Ms. Sudharani, this case be considered. At that junction, my lord, the respondent government issued speaking orders, my lord, stating that, my lord, the land is not adjacent to the one Ms. Sudharani's land. And that's how the proceedings were issued, my lord. Thereafter, another OA was filed, my lord. And my lord, from that OA, my lord.
What is the relief you are seeking? What is the relief you are seeking?
No,
what is the relief you are seeking?
Under displaced persons quota, my lord, the GOMS number 98, my lord, the petitioner is the owner's son, my lord, whose is acquired.
Rural project.
Yes, he's seeking appointment under displaced persons quota, my lord. My lord, PO is at 12 page, my lord.
You also find some OP?
That's for
to the land
compensation.
Compensation.
In the year 1905, on 1983, land was acquired, my lord.
Here is Jiva.
Jiva is at page 10, my lord.
Yes.
The relevant portion is at, my lord, the page 11, my lord. Page 11, my lord.
Yes.
Government have carefully examined the proposal in consultation with the AP Public Service Commission to provide jobs to the displaced persons of the project, their dependents on a regular basis. Keep such appointment outside the purview of the AP Public Service Commission and to reserve certain percentage of posts in the project for the displaced persons to ensure their appointment. My lord, the admitted fact is, my lord, the land is taken, the land is acquired. Originally, they state, my lord, that is not acquired for Jurala project, but it is acquired for the PJP camp office. By virtue of this Honorable Court's Division Bench order, my lord, even if it is acquired for ancillary purposes, they are entitled.
Where is it?
That judgment is at, my lord,
Page 24.
That is admitted fact, madam.
24.
Now,
In our major purpose, it is acquired, has to be.
that now it is not anything. Now the question is, my lord, at the time of acquiring the petitioner's father's land, my lord, petitioner was 2 years old. My submission, my humble submission is for that, my lord, if the land is not acquired, the beneficiary would be the son. Now his livelihood is being taken away.
Yes.
Therefore, my lord, petitioner, though at the time of acquiring the land, even if he is 2 years old, he is entitled. And my lord, in fact, his name was shown in list, my lord, at page 16, my lord. Petitioner's fathers. Page number 16, my lord.
Yes.
My lord, the third number, my lord, Kaza Mazaruddin. This is the petitioner's father's brother's land, my lord. He is given employment.
Page number?
Page number 16, my lord.
Page number?
My lord, serial number Gadwal, third point, my lord. In the my lord, it is in tabular form, my lord.
Yes.
Third, Kaja Mazaruddin. He is none other than petitioner's father's brother. And my lord, at page 18, my lord.
They show something else. Gadwal Pratap, son of Gindaya.
My lord, it is the adjacent land, my lord.
Serial number 2, not 3.
I'm sorry.
Raja Majaluddin. Yes. Raja Majaluddin is the brother of Krishna's father.
Adjacent land, my lord. Adjacent land of same survey number, my lord.
Yes.
And my lord, page 18, my lord.
About Krishna's father's
His father name is serial number 22 at page 18, my lord. Page number 18, my lord.
Yes.
Serial number 22, my lord. Kaza Abdul Majid, son of Qazi Sultan Moinuddin. His name was there in the list, my lord, but somehow, my lord, he was not given call letter. Other persons were given. Since then, my lord, in the year 2005.
Now, when the list is given, why? Already list is already figured. They were supposed to submit.
Again, teacher, I will try to bring to my last notice, my lord. My friend has pointed out the Khaja Mazaruddin. My lord, wherein kindly see the caste title. Petitioner name is Mujahid, father name is Majid.
Abdul Majid, yes.
Come to page 18. Page number 22.
Yes, my lord.
Raja Abdul Majid.
Mazaruddin, my lord.
22.
You are referring to page 16. Page 16. 18.
18 only.
1-8. Serial number 22.
22. I have seen the other number. Yes.
See this number.
This is Nasib.
I apologize.
My lord, page 22, my lord.
No, only point is, in fact, they were supposed to appear before collector on 10/1/1990 at 11 o'clock, along with the documents. Yes.
It's not heard and this case is not considered. Since then.
He has not appeared.
No, madam. No. He appeared when, my lord, but he was not considered. My lord, originally the petition was filed by Abdul Majid. In the 8.22, my lord, father, along with his son.
Yes.
This honorable court, honorable APAP, my lord, disposed of writ petition, my lord. The lordship kindly permit me to read
It's
page 26, my lord. Okay.
Page 22.
Page 24 is the OA order copy, my lord.
Yes.
OA 6135 of 2005.
Yes.
My lord, page 26, my lord. Just I'll read the relevant paragraph, my lord, paragraph 5.
Yes.
Heard both sides. Learned counsel for the page 26, my lord.
Yes.
The learned counsel for the applicants argued that as per GOMS number 98, it is nowhere mentioned that only persons whose lands were acquired for construction of project or whose lands are submerged alone are entitled for employment under GOMS number 98 and not persons whose lands were acquired for the purpose of construction of buildings in connection with dam. Para 3 of GO 98 reads that government have carefully examined the proposals in consultation with the APPSC to provide jobs to the displaced persons of the project or their dependents on a regular basis and to keep such appointments outside the purview of APPSC and to reserve certain percentage of posts in projects for displaced persons to ensure their appointment. Para 4 cross 3 thereof says, para 3 thereof says that preference shall be given with reference to the date of displacement and to those applicants whose houses and lands are acquired against those whose lands or houses only is acquired. So, according to the learned counsel for the applicant, GMS number 98 does not restrict the compassionate appointments only to persons whose lands were acquired for the purpose of project, only for submergence. Moreover, the learned counsel for the applicant further contended that similarly situated persons were considered by the respondents and employment was provided. The lands of one Srimati V. Sudharani, whose lands are adjacent to the lands of the applicants, which were acquired, was offered appointment through proceedings dated 23/10/2004 of the Superintendent Engineer Gadwal in terms of GMS number 98. In the circumstances, a similar cases were considered by the respondents for providing employment. The respondents are directed to consider the cases of applicants to provide the employment to the applicant as was done in the case of said Srimati V. Sudharani if they stand on the same footing as per their eligibility, suitability,
yes,
within period of 6 months. My lord, thereafter, my lord, The respondents issued the impugn proceedings.
Where is? Is
Technically, madam, my original file is missing the rest of
34?
the page 34, my lord.
34.
Page 34.
Yes. Next.
May I read, my lord?
Yes.
Paragraph 2. Sri K. Mujahid, son of so-and-so, has applied to District Collector Mahbub Nagar 27/5/2000 for providing employment under displaced persons quota. Madam, displacement is not under question. It is an undisputed fact, madam. The land is acquired.
Yes.
The above two applicants have approached the Honorable APET and filed OA number so-and-so, MA numbers, and the Honorable APET on 11/11/2009 directed the respondents to consider the case of the applicants to provide employment as was done in the case of Srimati Sudhara. If they stand on same footing as per their eligibility. It is informed that application dated 27/5/2000 of Sri K.A. Mujahid, son of K.A. Mazid, was examined by the selection committee on 19/2/2011 in terms of GMS number 98, dated 15/4/1986, and latest government instructions in GMS number so-and-so dated 3/11/2010. And it was informed that he was found to be not eligible for providing job by the speaking order stated 21/11/2011. As per the above speaking orders, were issued without comparing to that of Srimati Sudhara. As such, the Honorable APET has not accepted the said speaking orders and directed to reconsider as per the orders of the Honorable APET. As seen from the records, it is noticed that land of Srimati B. Sudharani was acquired for submergence at Mastipalli village, whereas the land of Sri K.A. Mujahid, son of K.A. Mazid, was acquired for PGP camp building at Darbar and was not adjacent to the acquired land of Srimati V. Sudharani as per GMS number 98 dated 15/4/1986. The persons whose lands were acquired for submergence only eligible for employment. Melon, now they reject for the saying that it is acquired for PJP camp office but not for the main project.
Next.
Now, my lord, the orders of this honorable court, my lord, division bench of this honorable court, my lord.
36. Page 36.
Yes, madam. Just honorable Justice Ishplay and yes, my lord. The order is at relevant portion is at my lord, page 32. Insofar as responding in the petition number so-and-so are concerned, it is their case that they have already been considered, but the orders of appointments are kept in abeyance in as much as their lands were acquired for the ancillary purposes and not for the main project. As observed above, when the lands are acquired, be it for reservoir, canal, or ancillary or any ancillary purposes, we are of the opinion that the displaced persons are entitled to be considered in terms of GMS number 98 dated 15/4/1986. Therefore, we do not see any merit in the contention raised on behalf of the petitioner here. Consequently, we do not see any reason to interfere with the orders passed by the tribunal. Hence, the petition failed and accordingly dismissed. No orders as to follow. Now, my lord, government saying along in their counter that, my lord, we have not applied. The lord said, kindly look into my reply copy, reply, my lord. I find reply affidavit, my lord.
Yes.
My lord, I'll just, it's only 4 paras, my lord. I'll read out, my lord.
Total, you won't just read clear.
My lord, they say is, my lord, we have not applied within 1 year. That also, from the date of acquisition, within 1 year, we have not applied. But that also the government had clarified by their own proceedings, my lord, it is not required, the exemption is given. In fact, there is no.
Where is it? Where is that?
I have stated in my reply affidavit, my lord.
Oh, where is the proceeding?
Proceedings is in their additional affidavit, additional counter expert, my lord.
Yes. Okay.
Page number, my lord. Is all good before another report, my lord. Somehow my paper is missing, my lord. Report, my lord, page, my lord. Page number 34 of the additional counter, my lord. Relevant paragraph is at page 35, my lord. 35. My lord, third paragraph, my lord. 35, my lord. The government, after careful consideration, my reader.
Yes.
The government, after careful consideration of the matter, have decided to relax this condition and order that condition of applying for appointment within 1 year from the date of displacement does not apply to such of the persons or families who are displaced prior to the issue of the said GO. Admittedly, my lord, land is acquired prior to the GOMS number 98. That is in the year 1983, land is acquired. The district collectors are there.
No dispute with you. There is no dispute.
My lord,
Acquisition of
there is slight difference in this. In this, my lord, there arises a differences between the family persons, my lord, regarding the compensation regarding the land issue. That was landed in the subcourt.
Right.
Subcourt, but kindly consider
That is
after passing of the subcourt order only, my lord, award is passed and the award certificates given subsequently, my lord. To this extent, there is a division bench order is there, my lord, wherein this matter specifically dealt to that point after award and after the certificate issued by the special deputy collector, my lord, issued the certificate, then only the 1 year limitation comes, my lord. Though the land or anything acquired prior to the GO, my lord. I have given last occasion, the earlier bench, the judgment, my lords.
So, but land is acquired prior to GO only.
Prior to GO, it's not in dispute.
So now
it's not in dispute.
That's what you want to. Now you want to say that because there was a dispute within the family members.
Yes,
for passing that order within 1 year they have to.
Yes, my lord. There, this memo doesn't come, doesn't apply, my
lord. Pending till light, my lord. In fact, my lord, it is not out of. It is relevant here, my lord. Article 13 of the Constitution of India, my lord, ex post facto laws. The law, the date on which it is acquired, my lord, from that date he is entitled. Merely the pending litigation within the families, my lord, that is not the ground for denying their livelihood, my lord.
There is a specific finding.
Once.
Division bench.
Wait.
My lord, I am unable to understand the division bench order, my lord. Can you provide me?
I have given last time to you. I have given to you.
Which time?
Yes.
Everything has built in advance. So Justice Vashiti Garu and Justice Chandra Marga.
Yes. My lord, just I'll read, my lord, para 3 onwards, my lord, the judgment which my friend is referring, my lord.
No, you complete that.
Let my friend complete our
right. Save your energy. Forcefully we can argue.
My lord, my energies are here not, my lord, since 2005, my lord.
I'm telling you,
2005, my lord, petitioner's father fought. And since day one of taking away the land, my lord, now, my lord, this entire family is suffering in harness, my lord, with the land, agricultural land, my lord.
Yes. They survive till now, my lord. They are in harness. Sorry, harness doesn't apply to this.
My lord, merely living hand to mouth is not the living, my lord.
Yes.
Having their land, my lord, even as per the welfare state, living with hand to mouth, my lord, and
yes.
I read out the judgment, my lord, the admitted paragraph 3 of the judgment, my lord. Page 3, my lord.
Yes.
Admittedly, there was a title dispute, and because of pendency of the dispute, the respondent could not have submitted the application for appointment
within the stipulated time as per GYMS number 98 dated 15/4/1986. Admittedly, the subcourt passed orders dated 22/12/1989. As seen from the record, Special Deputy Collector Unit Priyadarshini Jurala Project Gadwal issued certificate in file number so and so dated 11/1/1991 to all the individuals whose lands have been acquired, which reads as follows. This is to certify that lands in survey number so and so were acquired in Narasana, the village for submergence under the PJ project widely award number so and so. The land compensation in respect of above lands was deposited in subcourt Gadwal under section 30 and 31 of Land Acquisition Act, since there was dispute in ownership. In disposing of the case in IA number so and so, dated so and so, the Honorable Subcourt has decided that Savaran, son of Jajappa, is entitled for an extent of 20 guttas and guntas out of survey number 538, and value of the land amounting to so and so was awarded in his favor. It is clear that after passing the order under section 30 and 31 of the Act by Subcourt Gadwal, the Special Deputy Collector issued certificate on 11/1/1991. Even this is also prior to GOML. The respondent filed the application on 31/1/1991. It appears that unless certificate is enclosed to the application, his case could not be considered by the authorities. Here, such question is not there, my lord. He has not enclosed certificate that. My lord, if that is the question, why the petitioner's father was called for interviews by the collector, my lord?
Yes.
At page 16, my lord, we have seen, my lord. Therefore, the certificate of Special Deputy Collector was necessary for applying for employment. There is some other record filed along with this petition, which goes to show that Assistant Collector Gadwal, by the file number so dated 24/1991, called the respondent for interview when certain posts are sanctioned in election schemes to work as attender in general elections 1991. The Executive Engineer Priyadarshini Jurala Project Circle number 1, Gadwal, also seems to have addressed a letter to the respondent on 23/2/1993, asking him to furnish certain documents which include a certificate from the Special Deputy Collector, Land Acquisition. Therefore, date of passing of award by Subcourt cannot be taken as grandeur, but it is the date of certificate issued by the Special Deputy Collector dated 11/1/1991, from which period has to be counted. Moreover, it is not clear as to when the certified copy of the order dated 22/12/1989 was obtained either by the petitioner or by the respondent. In absence of any specific date showing as to when the certified copy of the order dated 22/12/1989 was obtained by the petitioners or by the respondent, it cannot be said that period commences from 22/12/1989. Moreover, the tribunal had only directed the petitioner to include the name of the respondent in the list of eligible displaced persons and to consider his case as per seniority in terms of GOMS number 98 dated 15/4/1986. Hence, we do not find any merit in the petition to interfere with the impugned orders passed by the tribunal. My lord, in a way, this is helping me, my lord.
Take aid of this judgment. Next.
Pardon me, my lord. I couldn't.
Take aid of this.
Yes, I'm obliged. Much obliged.
Yes.
Further,
Reply.
my lord, the impugned proceedings do not say anything about all these things, my lord. Now the petitioners, respondents cannot improve their cases by filing new papers or by filing counter.
Not a paper, man. Kindly consider one aspect. It's not a paper or not a proceeding. It's a judgment. We have like.
1 second, let him.
No, I'm saying that. My land friend is saying it's a paper.
Note down all the points you
Has
answered.
to follow the judgment of this court or other court.
No, precedents, judgments.
Reply. Just read reply. What you wanted to make some points.
Just only 5 paragraphs, my lord. I'll read out from second paragraph onwards, my lord. Kindly, my lord, because I addressed all the points raised in the counter, my lord. Reply,
Yes.
my lord.
Yes.
I respectfully submit that the contention of the respondent is that within 1 year, in fact, my lord, all these are raised in their counter, not in the impugned proceedings, my lord. My humble submission, my lord.
Yes.
Within 1 year, an application for appointment should be made, and that reason is being shown as ground for stating that I am not entitled for appointment. I respectfully submitted in reply to the said contention, the government by memo dated 28/8/1987, just now I read it, my lord, clearly provides that relaxation to the said condition, which reads as follows. Government after case for consideration of the matter have been decided to relax this condition of applying for appointment within 1 year from the date of displacement, does not apply to such of the persons or families who are displaced prior to the issue of the said. Hence, it is relevant to submit that the land of applicant's father was acquired by award number 7 of 1983, dated 19/5/1983. Therefore, the land of the petitioner father was acquired much prior to the said GO. Hence, the contention is unsustainable. It is respectfully submitted that the content of the respondent is that GOMS number 98 dated 15/4/1986 shall be meant for main project but not for connected works. It's absolutely unsustainable for the reason that the land of the petitioner's father was acquired for PGP camp colony, which is part of the Jurola project and qualifies him under the GO. The proceedings dated 27/9/1989 clearly admitted that the list of the persons for taking necessary action in terms of GOMS number 98, whose agricultural land is acquired under PJP or KLI, and the batch by the order dated 22/8/2011 held.
This is not this. Please also said this. This is not disputed.
Yes, sir.
Characterized
I respectfully submit that the contention of the respondent is that as per the District Collector Mehboob Nagar letter number so dated 27/9/89, Sri Kaza Majaruddin at serial number 2, whereas applicant name is at Kaza K. Mujahid, for which it is respectfully submit that Kaza Majaruddin in OP number 465 of 1987 is shown at serial number 15 in the list of the claimants, whereas name of the petitioners is shown at the serial number 10, whose land was situated adjacent to the others. In the list where we have seen, my lord, I'll once again show, my lord. In fact, the numbers are somehow missed. I stand corrected to that extent. Whose land was situated adjacent to each other. In fact, respondent number 4, while the letter dated 27/9/1989 to the third respondent, without there being justifiable reasons, petitioner's case was not considered as per the information obtained under Right to Information Act. It is made clear that Kaza Majaruddin's appointment was made as per GOMS number 1998. I respectfully submit that an application called for valid letter dated 22/12/1992, pursuant to which 88 persons were called for interview, in which the petitioner's father name was shown at serial number 22, consequence to which valid letter dated 22/2/1993 instructed the father of the petitioner to attend the office with original certificates for appointment under displaced persons scheme. Thereafter, father of the petitioner approached the third respondent requesting that, as per proceedings dated 19/12/2005, many similarly placed persons were appointed as attenders whose names were shown in the list of the candidates for appointment under displaced quota. And he is eligible and entitled for similar benefit, but all his efforts went in vain since then various applications and petitions were filed before the Andhra Pradesh Administrative Tribunal and before this Honorable Court. I further respectfully submit that the condition of the respondent that from the date of award, the age of the petitioner was below 2 years, for which I respectfully submit that since the date of the award, the father of the petitioner was continuously pursuing for extending the benefit under GOMS number 98. In spite of various favorable orders from this Honorable Court, the court's respondents under one or other protest rejecting high-handedly. My lord, where the petitioner's father's name was shown at serial number 10, my lord, somehow I mistyped.
No, what is the reason given in the rejection?
Rejection order page 36, my lord. Oh, sorry, my lord. Page 34, my lord. Page 35 is the
no, this here it's only say that since they were acquired for camp building.
That is overruled by a honorable bench order.
Only one ground, Mr. Only one ground. Rejection is only on one ground.
3-4 rejections are there, madam. After the rejections are there, I have come up in my submitted last in office, my last occasion. Chronologically, I have given everything, every date and everything. When my turn comes, I'll submit.
He will submit, my lord.
Continue further.
Thanks for giving permission.
Next, continue. You wanted to show something? Serial number 10? You want to...
Yes, my lord, I'm searching for that. In fact, before other bench we argued at length, my lord, somehow I missed my file, my lord. That's the reason that immediately I'm not able to show me. My lord, it's page 33, my lord.
Yes.
Prior to this impugned proceedings, my lord, the government issued another proceeding, my lord, addressed to the petitioner. Para number 2 of page 33, my lord, your land is acquired for ancillary purpose, but not submerged in the main project and cannot be considered under PAF project affected families for providing job of as
Same round.
Same
34,
round.
33, same. Next.
Same round.
Okay, that's all.
So he submits, my lord, if anything is.
You can give reply.
Yes, obliged.
Where is the
Page 17, my lord.
where is that chronology given?
Then I have given last occasion to earlier best.
Hey, one more point. Yes, chronology was there. No?
One more submission, I'm sorry, my lord. There was an interim direction in this petition, my lord, to consider his case to the post of Lashkar, my lord. They have rejected, my lord, and vacate is filed, my lord. Vacate is dismissed. And my lord, when there was
Okay, this is fine. What person to interim order? Any orders passed by the respondent? What?
speaking orders, when there was a.
That's what. By observing that vacate is closed.
Yes, my lord. Some proceedings were passed, my lord. I'll just search for that.
Right. Come.
Page 17 of the writ petition, my lord. Kindly come once again.
Petition?
Yes, my lord. Wherein my friend has relied on a proceeding where the petition father was called for the interview.
Yes.
Kindly observe the date, my lord. 20th 12/1990.
Page 17.
Yes, sir. Internal page 22.
Yes.
Kindly observe the date 20th 12/1990.
Yes.
Original date is not shown properly, but it is handwritten.
Yes.
In the paragraph, my lord. May I read, ma'am?
Yes.
కలెక్టర్ మరియు జిల్లా మెజిస్ట్రేట్ మహబూబ్నగర్ నిర్దేశనను సూచించిన తమ లేఖలో జూరాల ప్రాజెక్టు క్రింద భూములు మరియు ఇంకా కోల్పోయిన ఈ ప్రాజెక్టులో
No, this only this.
Where is the interview date? Kindly also that.
1990. 1990 they have asked to come.
Kindly proceed date is 20/12/1990.
No,
Interview date is 10/1/1990.
Probably there is some dates might be different.
That is one thing. And
in fact,
that is one thing.
If you see,
my friend have met in the.
No, you get the original card because I think there is some discrepancy in this.
No, I'll get regard to that effect.
Yes.
My lord orders me. And Everment also, my lord, my friend has said the date 22/12/1990.
Yes.
Page 4B. Page 4B.
Yes.
Second line. It is submitted to the executive engineer invited to the application from the displaced persons under Jurala project by this his letter dated 22/12/1990.
Yes. Should have been 2020.
Yes. Yes, ma'am.
Page melod, Tedi melod. 22, it is very, it is being shown melod, 12/1990.
But I'll get instruction regarding this proceeding. I'll get instruction regarding it. There is doubt arises on this aspect. And I'll kindly come to the chronology legal. I submitted, madam. Serial number.
So you're disputing this?
Yes, ma'am. Also, one thing lies, my lord. After this, petition father never acted upon. Why he has not given? I have also not made any amendment regarding this. Fairly submitting, my lord. Why he was not considered? And my friend also not said why he was not considered and why he has not proceeded. And what made the person who is about 2 years at time of award.
Yes.
Making a representation.
Wait.
My humble submission, all those are beyond the impugned proceedings, my lord. Contents of cannot.
I never interrupted her. I never interrupted.
The chance of reply you. Yes.
The chronological events, serial number 1. As per requisition certificate, the land situated in the limits of Gadwal village, Mandal survey number 775-777, measuring an extent of AC 11 acres 33 guntas and acre 2.330 guntas, totally to 1/16 share was acquired for PGP Camp Colony Award number 7/83, date 9/9/1983. Thus, there is no dispute, my lord, regarding the land acquisition. That is prior to the GO only, my lord. And compensation of rupees 1,74,819 was deposited in the subcode Gadwal as of the some family members of the applicant father.
One second. What else, sir?
This is land friends chronological events are given. Are the respondents? Yes, Mary from first arm. As per the requisition certificate, the land situated in the limits of Gadwal village and Mandal in survey number 775-777, measuring an extent of acre 1133 guntas.
Yeah, this is mine.
Yes, ma'am. And acre 2.3
for deposit sub
30 guntas. May I read from the down? Was deposited the subcode Gadwal as the sum of the family members of the applicant's father raised objection for payment of said awarded amount. Accordingly, the said matter was referred to the Honorable Subcode Gadwal under section 30/31 of the LA Act as per the affidavit made on 4/5/2005 and passed a decree in the year 1987 in OP 1983 of 1984 and directed to pay an amount of 10,926 to 29 to Khaja Abdul Majid, who is the petitioner's father. Further, the applicant received the award amount as determined by the Subcode Gadwal in the year 1987 and has obtained, kindly observe this, and has obtained a copy of the award from the Special Deputy Collector Gadwal on 31/8/1989.
Yes.
For which, my lord, I relied on the judgment which my lord has read. That judgment says that, my lord, from the date of the certificate issued by the Special Deputy Collector, my lord, that has to be taken into consideration 1 year, my lord. Thus, it is clear that.
But this is, you are reading from what is the basis for this, that they have obtained a copy on 31/8/1989?
My lord, after that award only, they have to obtain the certificate from the.
Correct, but they have obtained this copy on 31/8/1918. How you only this your chronology event, but any document is there that he has obtained on 31.
I have made a affirmative in my counter regarding this.
Supporting, what is the support for that? Is there any support document and material to say that copy was? No, continue. Just only I'm asking. Okay, you continue. Just only just keep in his mind.
That is after lapse of. Does it clear that the applicant seeking for appointment was made on? Kindly consider this after 27/3/2000, 27/5/2000, 29/5/2000.
Yes.
After 89, it is in 2000 only he made application.
Yes.
For seeking appointment displaced quota. After a lapse of more than 60 years from the issuance of the requisition, refuse certificate. Moreover, at the time of filing application, petition is minor on his date of birth is 10/7/1981 as per SS certificate. In fact, the application has made within 1 year itself as a provision contained in para 3 of June 98 dated 15/4/1986. Hence, the applicant is not entitled for appointment as the application was not made within the period of 1 year. As per the subcourt order, the compensation was paid to the father of the applicant in year 1987, but not in year 1983. Hence, a memo 480, which my land fund had relied, dated on 24/8/1987, is not applicable to the case of the applicant because father of the applicant received the compensation after the issuance of GO 98, dated 15/4/1986.
No, this GO 480 only says that the
award,
not
that land acquired prior to
land acquired.
Yes, yes. As per the judgment of Honorable AP High Court in repetitive so in this case, the petition land was acquired, by award 10/87 dated 7/3/1987 as there was some title dispute referred to subcode under section 3031 of LA Act 1894. The subcode has passed the order on 22/12/1989 in IA so and so dated in OP 251 of 1987. Petition obtained the requisition certificate. It's only a repetition, my lord. Further, my lord, a petition father has furnished in notarized affidavit dated 4/5/2000 that his son Sri A.K. Mujahid, 20 years, is uneducated and is having no avocation and he is unemployed. As per R4, the district collector Ahmednagar letter dated 27/9/1989, the Khaja Mazaruddin, son of Khaja Rahimuddin, is at serial number 2 and was appointed. But the applicant name was K. Mujahid. Also, his father name was Abdul Majid, is not covered in the set list, hence not appointed. The district selection committee has perused the petition application made on 27/2000, is rejected on 21/3/2011 on the two grounds that failed to submit application within 1 year. Land was acquired for ancillary purpose, that is canal and roads, etc., but not submerged in the main project and cannot be considered under PAF under memo dated 28/11/2005. The applicant's father and son filed OA 6135 of 2005 for seeking employment under provision GO 98 dated so and so. Again, as a similar situated person, B. Sudharani. At the time of admission, the Honorable APT has passed interim order dated 7/10/2005 and directed the respondent to dispose the applicant representation. Subsequently, applicant has filed MA 132 of 2008, trailing to direct the respondent to provide employment to either of the applicant under displaced person quota on the basis of their placement in the list of 1989. The APAT has passed the final order in OA so and so on 11/11/2009, directed the respondent to consider the case of applicant to provide employment as was done in the case of Srimati Sudha if they stand on the same footing as per their eligibility, suitability, and seniority. Subsequently, applicant has filed a CA number so and so in the OA number so and so with an MA so and so. The compliance of the court order, the third response has issued the speaking orders dated 27/9/2012, stating that the applicant is not eligible for employment as one of Srimati Sudharani land was acquired for submergence at Mustipalli village, whereas the land of the applicant was acquired for PJP camp building at Gadwal, and not adjacent to the acquired. It's not in adjacent to that manner. Hence, the rejected. The Honorable Court was pleased to close the contempt and pass the order with the liberty to challenge the speaking orders dated 27/9/2012. The applicant filed OA number 3038 of 2013 and questioning the rejection order 27/9/2012 passed on 27/9/2012 by third respondent. At the time of admission, the Honorable Court has suspended the rejection order and passed the interim order dated 26/4/2013 follows. Pending disposal of the OA, there shall be interim suspension proceeding of so and so issued by the third respondent. The respondent directed to consider the case of applicant for appointment to the post of record assistant as his land was acquired for PJP camp colony, which is a part of Jurala project and qualifies him for the benefits under GO 98 dated 15/4/1986 without any limitation. The orders in this regard shall be passed within a period of 4 weeks from the date of the receipt of the copy of this order. Further, on compliance of the court interim order, the third respondent has issued the rejection order dated 5/6/2013, stating that he is not entitled for providing the employment under displaced person quota as he was below 2 years as on the date of the award. And as per the SSC memo, his date of birth is 10/7/1981 and the award is 7/83 dated 9/5/1983 as per GO MS 247 dated 29/12/2008 para 10. The third respondent has passed the rejection order dated 5/6/2013. The same was brought to the notice of the APAT through vacate petition in BMA 879 of 2014. The petition filed MA number 3362 of 2013, OA 3038 of 13 and MA 507 in 13 of 13 before Honorable APAT seeking amendment of the main relief to set aside the speaking order dated 5/6/2013, which was passed by the third respondent as compliance of the interim orders in OA number 3038 of 13, 26/4/2013. It's worthy to bring to the notice that above said MS never ordered mallet. That MS were never ordered. Meanwhile, the Honorable APT ceased to exist after the state of Telangana, and subsequently this matter was transferred to the Honorable High Court OA, which is numbered as WPTR 502 of 2017. The same OA is now in WPTR, wherein MS were never ordered, madam. And MS also number, MP number, MPT number, WPMP TR number 28 or 27. And same is pending for consideration before this Honorable Court, High Court. On 8/3/2018, the present WPTR 502 of 2006 came up for hearing before the Honorable Court along with WPMP 104 of 2017. The Petition Council has not brought to the notice of the rejection order, madam. Kindly observe this, madam. The Petition Council has not brought to the notice of the rejection order passed by the third respondent on 5/6/2013 for compliance of the interim orders in OA 3038 of 2013 passed by the Honorable APT on 24/4/2013. The Honorable High Court passed the interim orders. The direction in the interim orders passed in the OA being one only for consideration of the case of petition for appointment to the post of recorder. I see no reason why such order should be vacated at this observation of this court. I see no reason why such order should not be vacated at the point of time. Therefore, WVMP 104 is dismissed. Petition has filed CC number 2387 of 18 in WPTR, present WPTR, non-compliance of interim order passed on 8/3/2018. On compliance of the Honorable High Court order dated, third respondent has brought to the notice of the Honorable High Court that MA number 3362 of 13 and MA number 507 of 13, which is numbered as WMPTR number 28 of 27 is never ordered, and therefore there is no orders were passed on the speaking orders 5/6/2013, madam. The speaking order subsists in the present scenario, madam. That speaking order still subsists, madam. It is also evident from the Honorable High Court dated on 8/3/2018 that no orders were passed to the effect of challenging the speaking orders 5/6/2013, and which is clearly shows that speaking order dated 5/6/13 is still pending. Now it's clear that the order of APAT on 26/4/2013 and confirming the order of Honorable High Court on 8/3/2018 in one and the same. And for this order, the respondents already issued the compliance report on 5/6/2013. As per the rejection order passed by the third respondent 5/6/2013, the Honorable High Court dismissed the contempt so on 26/10/2018 and given liberty the petitioner to challenge it, and already challenged by way of amendment petition in OA. Petition has filed IA 1 of 2019 on 11/12/2019 for amendment of rejection order 5/6/2013 by a third respondent hearing. The same was pending for adjudication.
Yes.
That's the thing.
Okay. In fact, the chronological events were directly supplied to the melon because new points is raising melon. Basically, last petition also when I asked that chronological events melon, my friend was saying that it is my
submission, melon. How I prepared? How should I give her? It's my preparation. There is order, there is additional order. She can go through that.
Well, she was only saying that you are making new points, but
well, I give it Mallard's asked me to give. I will give it Mallard, but I have a doubt on that proceeding, Mallard, which I learned for pointed out.
Correct, but where is it possible? If you have original record, you can put it.
I'll try.
You also say that it is nothing is less than this and fabricated.
I will try to.
But anyway, your matter, but your case is your contention is covered in the DB order. That after
yes, ma'am.
Award is passed within 1 year.
Yes,
but that was given that there was no date on which the award was in fact obtained or supplied.
Also inquired whether why the petitioner's father earlier not considered to that of proceeding which my friend has produced.
Yes.
As of now is also melon. Land is acquired. It is not in this case. Land is acquired. Land is taken away. But for merely they are trying to support this case on technical grounds, melon. I could answer those points from my content application, melon. Just it is not a fact of Melod's record, melon, but it is from my personal content office copy, melon. On 26/3/2013, melon, Honorable APAT passed pending interim orders, melon. Pending disposal of OA, there shall be interim suspension of impugned proceedings dated 27/9/2012. Against which melon, the government filed vacate melon, WBAMP 2. He says that there is no interim order melon. In fact, that there is an order interim suspension of interim proceeding passed by the third respondent, and respondents are directed to consider the case of the applicant for appointment to the post of record assistant as his land was acquired for PJP Camp Colony, which is part of Jurala project and qualifies him for the benefit of GOMS number 98 dated 15/4/1986. This interim order is dated 26/4/2013, my lord. Against that, my lord, the government filed vacate, my lord, BMA 872 of 2014. That was dismissed with the observation that, my lord, this application is filed to vacate the interim order dated 26/4/2013 passed in OA number 3038 of 2013 on the file of Andhra Pradesh Administrative Tribunal at Hyderabad. The tribunal has passed so and so order, just now which I read, my lord. GT is directed to file counter. The direction in the interim order passed in OA number being one only for consideration of the case of the petitioner for appointment to the post of record assistant. I see no reason why such order should be vacated at this point of time. Therefore, WBMP TR number 104 of 2017 is dismissed.
Yes.
So he says, my lord, there is no interim direction, my lord. When there is no interim direction, the question of dismissing the vacate petition do not arise, my lord. My lord, trying to improve
In that interim order, we have passed the speaking orders, which had been brought to the notice of the court. After that, observing that speaking orders only, the
Where is that speaking order? Where is the speaking order?
Which is
Same 21.
Find amendment to that amendments were never ordered. In MA.
No, where is that? The date of that speaking order?
The date of speaking order is 5/6/2013.
5/6/2013.
Yes.
You have placed on it?
5/6/2013 is the interim proceedings in the present writ petition, my lord.
No, Mr. Akram, have you placed this?
My lord, now the interim.
The speaking order is placed on record?
Have
you placed on record?
Yes, he says, my lord, interim proceedings is 5/6/2013. Kindly, your lordship, may look into the prayer in the present writ petition.
So only asking one whether it is placed on record or not.
It's filed in the counter, ma'am. Additional counter.
It is filed.
Page 14 and 15. There, ma'am. Well, I will try to produce the that proceeding ballot. 1990.
1415 counter 1415 is different. Page number 1415.
Additional counter, madam. Twentieth October 2019 we have filed.
Yes.
My lord, page 8/6 of my affidavit, my lord. Hence it is. Page.
Yes.
Page 6 of my affidavit, my lord, which is main release, my lord. Page.
Yes.
6, my lord, para 8, my lord. My friend says, my lord, present interim proceedings I have not challenged it, that is dated 5/6/2013.
Yes.
Hence, it is just unnecessary that this Honorable Court in Tribunal may be pleased to call for the records relating to the proceedings of the third respondent bearing number so-and-so dated 27/9/2019 and speaking order number so-and-so dated 5/6/2013.
Yes.
And set aside the same.
Yes.
Challenge, my lord.
That is never ordered, I said.
Amendment already there.
It's never ordered, I said. It's pending, I said.
Amendment already.
1 of 2019, which is filed on 11/12/2019 for the same proceeding amendment of.
No, amendment already carried out. The court record.
If that is the case, I stand corrected.
The IA number?
IA 1 of 2019. 11/12/2019. Seems IA 1 of 2019 is also listed, which is shown in the list also.
Okay, where? There is no presuming where the IA number 1 is in fact stored.
But in the list that is showing suspension petition, madam. IA 1 of 2019.
Online letters.
No, even when that IA was allowed, the docket person doesn't say that is IA is allowed. How this amendment was carried out?
But I have a petition which my friend filed, which is filed on 11 December 2019.
So December?
11 December 2019.
That is there, you can only for what is there? It is there.
That is after. It is this diversity.
IA 9, dated 9/12/2019. Suspend the proceedings. Where is amendment? It is IA.
Suspension petition, madam.
Suspension is there, but how in this? How this is come on the phone? Amendment is carried as per the orders of tribunal. This tribunal's order 23/1/2014. Tribunal order.
Before the tribunal itself, this 5/6/2013 is under challenge, my lord.
That is not order.
No, order.
This was not order.
Tribunal instance was allowed in tribunal.
Oh.
23/1/2014.
That's time corrected.
Right, next. That's all. How we waited and we wanted to get the proceeding in the way. Proceeding.
By Thursday, I will get it. But if that is the right, pass orders. When proceeding is.
It will come on for orders.
Yes, for orders. For orders. That's in. Pass orders.
Exception orders. These people.
It's going back, and because it is a retirement benefits matter, and retired in 2015, finding 2017 matter, and because insist after motion list.
Next.
Tomorrow. Number 63, the day will ask us to directly reach to court for our principal matter. The teacher will also have gone to the physical particular issue. The same issue dealt by the other court on the day also of the hearing at length. Dictated some order. And later the AGP to go to judgment. We ourselves argued that matter.
I have not directed to get heavy judgment, your lordship. I have argued at length. Lordships have posted your lordship for final hearing at my request, because I have only to make 2-3 submissions, because petitioner has been promoted, your lordship. That clarification, for seeking that clarification, I have sought that. Now I received instructions, your lordship, stating that petitioner has been promoted. Petitioner has been reinstated, sir.
It's an issue in Shoka, it's on the day. The same issue, Pelpa consideration, we argued.
My only
Then was
submission,
the
my
teacher issue.
only submission for the lordship is Shoka's notice, if is not made available. They have to.
So that you are on.
I stated so on that day also, your lordship. Now also, just now I received instructions stating that petitioner has been reinstated, yes.
Instead of Malak, seen the judgment wherein Shoka's notice can be challenged or cannot be challenged. The judgment may have ceases.
Let it come tomorrow. Then we'll continue. The list will continue. The list will continue. It will almost. I think it will come up tomorrow. I think it will reach. We'll see.
Before lunch or after lunch, madam.